Hello, hello. It's a double header today. We have 2 live streams on this channel. Welcome back. If you were here for my interview with Gabby Hoffman, I was going to say Gabriella Hoffman. Gabby Hoffman is usually what she goes by. I had a really great interview with her talking about one of Biden's recent nominations for the Department of Labor. His name is David Weil. We had a lot of talk about independent contracting and regulations around that, and how some of the laws have changed over time. She's not a lawyer, but she knows a lot about this kind of stuff, but because she's been very involved in this space and writing about this space and consulting and all this kind of stuff. So anyhow, if you were there, welcome back. If you weren't, you might want to go and check that out. And if you are absolutely new here, my name is Alita. I'm a lawyer licensed in California and DC. And on this channel, we explain the law one bite at a time. So currently, I actually have 2 guests with me. Hello, hello. Welcome back.
It's Nate the lawyer.
Hey,
We've
yes.
We've got our regulars, right? We've got our regulars.
I have questions for both of you right
Oh.
at the start.
Okay.
These are not trick questions. The first question is, assume that you're a federal district judge and someone wants to appeal because they think that you made an incorrect finding of fact.
Okay.
What is the correct standard on appeal for review?
De novo, no?
An incorrect
finding of fact. Incorrect finding of fact.
That's the basis of appeal?
Yes.
it's
Someone is
de novo.
appealing you because they think you made an incorrect finding of fact. What's the correct
de
standard on
novo.
appeal?
De novo is if the issue was an issue of law.
Right.
Right. That wasn't preserved on appeal. So I don't know.
Clear error was the answer to this question.
Oh,
yeah.
I'm sorry. I was actually this went horribly wrong. I'm sorry. The reason I was asking is because there was someone being nominated to the Southern District of New York as a federal district judge.
Okay.
And they were testifying in the Senate, and they didn't know the answer. So I was kind of hoping that we'd be able to show them all up. But yeah, no.
I mean, we basically got there.
You guys got there.
Also, they didn't know. They also didn't know the answer to the other one. By the way, they're appealing you because they think you made an incorrect legal determination. What is the correct standard of review?
They didn't get that right.
They didn't know the answer. No, they didn't know the answer.
That's bad. That's one L status. That's the one
L.
No, yeah, they didn't know the answer to that one. Yeah, what they said is I've heard of these concepts called de novo and clear error and abuse of discretion, and I know it's one of them.
Yeah, abuse of discretion and de novo is usually the one that you hear a lot.
Abuse of discretion is clear error is for findings of fact. De novo is for incorrect decisions of law, and abuse of discretion is okay. Never mind. Yeah. They didn't know the answer. Also, they were unfamiliar with principles of securities law, which Southern District in New York. So yeah, they may not be the most qualified nominee of all time. I just would like to offer my nomination at this point to Biden because I know the answers to these questions.
But you also have to realize that a lot of times district court, trial court judges and trial court attorneys don't really practice in appeals, so they may not be familiar with those appeal standards.
I don't really practice in appeals, and I know the answers.
But that you read appeal cases every day, though, right?
Yes.
This is why he's been rehearsing. He's been rehearsing for his job interview to be nominated.
Yeah. I know these answers. I know that one. How are you doing, Good Logic?
Yeah, Good Logic.
Yeah, how's it
going? Oh, no, I'm about to catch a Taurus here. Are
you sure it's not a Snorlax?
No, Taurus is way rarer.
Is it?
I gotta concentrate. Oh, this guy's so many ultra balls. So many ultra balls. I'm hitting with the ultra balls.
Joe and I had the best time yesterday going over that Pokemon Go case with the cops that got fired. We had so much fun. And also, fun fact for everyone watching. If you weren't watching yesterday. You know what I'm going to say. You know what I'm going to say.
Not true.
Good Logic is a huge Pokemon Go nerd. Such a huge nerd. It was awesome. He was giving so much great context for our live stream. It was fantastic. I wouldn't have known. So many things that I wouldn't have known, like the difference between like a regular ball and an ultra ball and a mega ball, and like, you know, he's like I know because I have so much hands-on. Oh, sorry, a Powerball. He's like,
I made that up. That's a lotto term.
Oh, okay. Well, whatever. I wouldn't have known. but you know, he's like, you know, I know because of my extensive time that I spent on this game, on this app.
This never happened.
He said it was over. It was over 2
right now.
This never. That was the joke. Actually, yeah. No, I'm actually been evicted from my house for like a few hours. So while they're doing work in my house. They're doing work in my house for a few hours, so I'm sort of out on the road. And that's why I thought it was a perfect setup for the whole Pokemon comment. And yes, what I admitted yesterday, to those of you who were not here yesterday, I admitted that roughly 5 years ago, I spent like 2 months playing that game, fairly regularly.
It was a thing at my work for a while, where people were gathering at the water fountain, because there's this nice water fountain outside my work, and people would gather there like every afternoon to play Pokemon Go, and I was like, "Key, this is a thing that's happening now."
Yes. Yeah. It was kind of cool. It's kind of cool when you have your camera open and all of a sudden there's like this cartoon virtual reality character. You're like looking out. It's like you're just looking out like on your sidewalk, and all of a sudden there's like this virtual reality character that's there briefly, and you get to interact with it by trying to like catch it. It's kind of a cool concept. So it was very novel. You have to give him credit. It was a very novel idea. Bringing virtual reality, augmented reality was just a very creative thing. But I cut you guys off. You were having fascinating conversations about Kurt's impending nomination to the Supreme Court. Who are you replacing? Breyer?
Breyer would be fine. Need to go. Yeah, Breyer drives me crazy. Sotomayor, it doesn't drive me as crazy. So yeah, but Breyer drives me crazy.
Breyer always drives you crazy.
It's almost like he and Biden have one brain, and you're not sure like who's using it today. So
it's interesting. I've met both Breyer and Sotomayor. So
really,
well, New York City Bar Association. They come to association events.
Yeah.
I met Ginsburg. She was the justice who I don't know how they choose these things, but she was the justice who I guess got drafted to spend time with the new Supreme Court swear-ins. So I don't know how they choose that, but Ginsburg lost the race, I guess, and so she was the one who got to spend time with us when I was sworn into the Supreme Court. So that was kind of cool.
I met Kavanaugh at a rave, so there's
okay.
Oh, all right.
I'm totally kidding. Totally kidding. Me and Christine Ford Blasey. So.
Oh boy.
Man.
Oh boy. Oh no. Well, let me get the super chat really quick. Just a quick thank you to Aaron Catron or
good job, Aaron.
Katrin. I'm sorry if I'm one way or another I'm butchering your last name, and I apologize. But thank you so much for the super chat. I really appreciate it. So let's talk about these two decisions that came out yesterday. We've been waiting with bated breath ever since the oral arguments were live streamed. And we all had our thoughts on what was going to happen, and I think it pretty much happened as we mostly expected it to, right?
Yeah, I thought the OSHA was going to go down because for two reasons. Just a process argument. It was under the emergency rule issue where you can make an emergency regulation. So I thought that you didn't have enough for that rule to survive. And then I thought the Medicare one would survive because I thought the government had a better argument, unless they failed somewhere in the process. So both happen to happen because I understand this court is a very conservative court. So when you're talking about mandating 100 million people, they're going to really, really, really nitpick on that. But when you're talking, but then it's when you look at these two rulings, you can read the first one and take the rationale to the first one and predict the second ruling. Yes. Because the first one was like, this is too overbroad. If we were just talking about healthcare or some limited parts and places, then it would be good. And then when you went to the second one, it's like, well, we're only talking about healthcare and it's very limited to this particular, and they've done it before. So in one instance, they were like too broad, and the second instance was like, okay, this is exactly where we're gonna go.
Someone is echoing or feedbacking or something.
I think so. I think it might be your volume, Joe.
Oh,
your earbuds.
Yeah, I'll turn it down. I had it raised a little bit. I'll lower it.
Okay. Yeah. So, there we go. Oh no, I can still hear it.
Really?
Oh no.
Is that better?
I think so. Yeah, it's better. I can still hear it a little bit. Oh no, I can still hear it.
Yeah, it sounds like kind of like
just
a radio.
Just mute when you're not talking.
Yeah,
there
we go.
Talking.
That makes sense. That makes sense.
It'll be good.
Yeah, there you go. It's gone.
Yeah.
So I was gonna say I was reading the OSHA opinion before I was reading the CMS opinion, and I when I came to that part on page 7, I noticed that I was like, ooh, this feels like foreshadowing right here. Like, this sounds very interesting. I wonder what they're gonna say in the next one. I mean, I knew obviously how they ultimately ruled before I read the opinions, but I was like, maybe this is gonna take some play some role here in moving forward. So but I wanted to, I mean, we can talk about some more general thoughts before we do this, but I wanted to go through the actual at least the majority opinions for both of these, just so we can go through and so people can understand the rationale and sort of why they fell the way that they did on these two different opinions. If I don't know if that's all right with you guys, that's what I would like to do.
Can I just weigh in with something here?
Always.
Just before you get started, have you guys actually read through Jacobson? Have you read through it?
Yes.
Okay.
I've read through
so
it.
I want to clarify for some people here, and tell me if you disagree with my take of what Jacobson is actually saying. A lot of people make a big fuss about the whole $5 opt-out. And yes, factually, that was a big deal, but they actually don't talk about it very much at all in the decision. Mm-hmm. They actually focus very little, if ever mentioning it. Mm-hmm. The logic that they basically stress is that the reason why is that the government can pass such a law is that the government is a police state, which is able to pass laws to protect the health of the public. And if the laws are logically going to actually meet the aims that their ambition is to reach, then it must be passed. And they go on, if you look at it, it's 197 U.S. 11. If you go to page 38, which is the second to last page, the court actually predicts a dangerous problem that may happen in the future as a result of the Jacobson decision. And they say, we want to be clear. We want to be expressly clear that no one should misapprehend what we're saying here. And we think we've been clear throughout this thing, but in case there's anyone who missed it, we want to be expressed that the reason that this is viable and a workable thing is because it's meeting that aim. And we can foresee circumstances where if it's not actually meeting the aim, in that case, a court is obligated to strike the mandate down. And they also focus on vaccines. They say, you know why this vaccine is good? Because science has proven that these vaccines are effective at stopping the spread of smallpox, and our goal is to stop the spread of smallpox. So since these vaccines are meeting that aim, that's why this law is good. But if it's not going to be meeting the aim, the court must strike it down. Accordingly, when the CDC, the director of the CDC, has gone on record as saying that Omicron, which is the big brouhaha today, that the vaccines have no impact on stopping the transmission of Omicron variants, in that case, these mandates are not meeting the aim of stopping the spread. And accordingly, it's Jacobson itself which directs us that the court is obligated to strike down these mandates. Because if it's not meeting the aim of stopping the spread, which are what vaccines traditionally were always supposed to do, and this one does not, as admitted by the CDC, by law, by precedent of Jacobson, the court is obligated to strike this down. Tell me how I'm misreading Jacobson or misapplying Jacobson, if you think that I am.
All right, two things. There's not only one way for vaccines to be effective, right? Vaccines are effective in two ways. One, the stop of the transmission, but two, also the hospitalization issue, right? If you take the vaccine, you're supposed to be less likely to be hospitalized, because there are two issues with this virus. And I think a lot of people don't recognized that there were two problems. The first problem was obviously deaths. And I think like 0.3% of people who get COVID or die. So that's a 0.3%. So it's a very, very low. But then the second thing was hospitalizations. You having people overrun the hospitals, and that could lead to more deaths. For instance, if there's no more hospital beds, then somebody who has a car accident would get, couldn't go to the hospital. I think that was happening in Italy a lot at the beginning, where you had people who would have a heart attack would have to drive 2 hours away to go to a hospital. So those are the two things that this one was trying to overcome. But to answer your question more directly, if you read these opinions, the most recent Supreme Court opinions that we just read through now, they specifically say the efficacy of the vaccine was not the issue that they were there to resolve. That is not the issue that they're there to resolve. And number two, they also say in those opinions, especially if you read the Medicare opinion, they also say that this is a vaccine on par with the other vaccines like polio and so forth and so forth. So, an uninformed opinion saying this is not a vaccine, that's one thing. But the Supreme Court has made it very clear that these are vaccines, and the reasoning why they're letting these vaccines go forward for the Medicare issue was because of it's what did Thomas say? Thomas says this is not about efficacy, but about constitutional authority to do so. So I agree. You may be correct when it comes to Jacobson, but the court here has made it very clear that these are vaccines, they are effective, but even if they are not, that is not on the table.
Right? Here's the question to throw back at you, and I appreciate your response, and it's a well thought out and well reasoned response. But when you have a CDC director saying it doesn't inhibit transmission, when the CDC director is admitting that, this is not something that's like we're debating the efficacy. We know the lack of efficacy, and it's an admission by the government itself that there is no efficacy. So it's not like we have to try and weigh what type of efficacy. This admission serves as a directive to the courts that they must strike down the mandate. I mean, you want to talk about the hospitalization element? Okay, that one. I need to think that element through. But to the extent that it's being argued that we need to stop this thing in its tracks, and that's why we're doing this. Well, the admission from the CDC means that it's not a debatable point about the efficacy, and accordingly, Jacobson should be directing us to strike down this mandate. So tell me where I'm wrong, Kurt.
Well, what you're getting wrong there is you're speaking about Jacobson and the CDC in the same breath, which is, in my view, a mistake. Because the CDC is a federal authority. Jacobson speaks to state level authorities. So we have to make sure we get these concepts separated. So the ability of the federal government to have a mandate and the ability of the states to have mandates are different questions. So when you're talking about Jacobson, you're talking about state level authority, not federal level authority. So saying what the CDC director says or doesn't is kind of irrelevant to Jacobson, because Jacobson would speak to what some state level health commissioner would be promulgating whatever regulation for, and the purposes directed there too. So I take exception at that conflation.
No, Kurt. I love you, brother, but you're mistaken. The reason you're mistaken is because the CDC, this is a federal directive, and the CDC is the agency of the federal government. Right. It's their own agency which is saying it. It's not like I understand.
I understand that, but when you're talking about
saying it,
right?
Well, hold on. I just
when you're talking about Jacobson, you're talking about state level issues. You're conflating state level issues and federal level issues.
But that's because
I also just to throw this out there too, the CDC director said in it, what you're saying said it in an interview, but has also come out and said that was taken out of context, and obviously the vaccines are effective and provided data to show that the vaccines were effective.
January 10th.
So hold on. I know, but
3 days ago.
But I'm looking at literally. She says right here, CDC director says her COVID comments was actually highlighting effectiveness, but it was taken out of context, and then provided data to show that it is effective, right? To show the effectiveness. If you get vaccinated, you're less likely to get infected. You're less likely. So I'm just saying. So you may be right. She said it, but I'm telling you the most updated things that she has said right now from an interview is you said it happened on January 10th. This clip from her retracting it is January 11th. So it's the day after what you're saying. So you may be right.
What she corrected was basically saying, hey, these vaccines work so that you're not going to get sick. But she didn't correct anything with respect to its efficacy in stopping transmission. And that's what that's the whole point to passing these mandates, is we don't want people to get sick in the workplace. We have a fear of transmission. So she never dialed back that element of it. And that's the key element for a basis for passing this mandate, is that we're concerned about widespread transmission. With respect to what your point is, Kurt, the fact that it's federal government doing it just makes this that much worse, because the basis for a federal government to employ this rather than a state level thing, when you're talking about an employer-employee relationship, is that much more egregious that the federal government is looking and trying to deal with that at all. But if you're going to open up and say, okay, you know what, even though really the federal government shouldn't, but in this circumstance, for one reason or another, because of some basis that certain justices on the court thinks are legally viable, we're going to allow the federal government to step in here and try and pass regulations. Well, then in that case, those regulations still have to comport with Jacobson's requirement that you're not violating the Constitution. And the way you're not violating the Constitution is if it's meeting the aims that you're setting out to meet. And when your own agency, the own federal agency, it's not a state, it's not a local state, it's not Vermont's health agency which says that there's no efficacy on stopping transmission. It's the federal government's agency which says there's no efficacy in stopping transmission.
But Joe, I have to take issue with all right, she gave an interview. She said what you said during an interview, right? We're not talking about testimony. She said what she said during an interview. Then you're now saying, well, since she said that in an interview, she should change health policy, which may be true, right? If that's the case. But then the next day she said, well, that was taken out of context, and this is the correct thing. So, but what you've been doing is saying, I'm going to ignore the correction and then hold her accountable for something that she said herself that she didn't mean to say. So I think at this point,
I didn't ignore it.
I'm thinking at this point, we're being unreasonable to just say we're going to give all the credence to something that she said she didn't mean to say, or something she thought we was taking out of context, to only give credence and then forget that she says, hey, you know, I misspoke when I said this, but this is actually what I did. And then they provided data to show the effectiveness. Like, here's the data that we have. So, you know, if you're telling me to believe her misspeaking in an interview over the data and the correction, then I'm just saying, you know, I can't get
Nate,
the point isn't great.
That's not what I said, Nate. What I said is I'm going to take her words as of January 11th, not January 10th. Take her correction. Her correction does not do anything to take back with respect to the efficacy on transmission. She said it has efficacy with respect to keeping those who are infected from getting gravely ill. She did not walk back anything with respect to the issue as to whether or not it's stopping transmission.
Okay, I understand what you're saying now. All right.
So therefore, if the whole goal of this is to stop transmission, in that case, we're left with her statements taken in toto, both parts of it. And still, the federal government's agency is saying it's not stopping transmission. So why is it? So go ahead.
So I think that there are a number of reasons why, and we'll get into. I really want to read the actual opinion.
All right, go ahead. I'm sorry. I diverted us.
But I will say that, you know, having read the majority opinion on it, that for the CMS opinion, the court, you know, listed a number of reasons why they think that it's as far as a policy reason within this particular limited scope under the CMS, that it is that there are policy reasons for it, and it's not just to decrease transmission to patients, but it's also to increase the number of people that are available for the workforce to be treating patients, whether they are COVID patients or non-COVID patients. And so, if you have a vaccine that is maybe has no effect on transmission, but it does have an effect on the symptoms that people get, the length of their symptoms, that means that they have employees that are out of work much less. They are back in work. They have a higher opportunity to be back in work and treating patients that need to be treated, so that they have a lower healthcare worker to patient ratio, if that makes sense. So that's another reason.
That's a logical point. That's a valid counter argument. That I respect. I will point out that they've been going so far on this thing, on the requirement for vaccination, that they have, when they've been short-staffed, they've literally brought back in vaccinated, COVID-positive healthcare workers, and saying to the uninfected, non-vaccinated ones, you have to stay home. And I don't understand that logic at all. That is the most ridiculous. That's like saying
agree.
I don't want to have a guy who looks shifty around me. I'd rather bring in someone who I know is a burglar to watch my money. That's literally what it's saying. I don't want to have someone who I have concerns. He looks like the type of guy, he needs money. He looks like the type of guy who might steal. I want to bring in the guy who we know is a burglar. That's essentially what this is saying. This is doing.
Well, I haven't had the opportunity to run a background check on this other guy first, but I know that this guy
is a bad guy.
Yeah. But he's on the
mend. Maybe I don't know.
Maybe not, right?
but yeah, no, I completely agree with you on that. I think that it has, and I thought about that too as I was reading the majority opinion on this too. That I was like, well, that's an irony right here. Is the workforce issues that they've had specifically because of this mandate. And the way in which they have decided to bring in, COVID positive but asymptomatic employees, and it's a very, very concerning policy decision, in my personal opinion. Obviously, not a doctor. None of us are doctors. I feel the need to say it. We get in the comments. We get in the chat. We are not doctors. We're lawyers.
I'm a jurist doctor.
But I do want to.
We're doctors of the laws.
But I do want to make it very clear. There is a line in that opinion where Justice Thomas specifically says this has nothing to do with the efficacy of the vaccine. This is all about the process in which these rules and regulations are fulfilled. So, Joe, even if I grant your point, the justices, the most conservative justices, says this is not even about that. This is about whether the government has the ability to do that. So,
yeah. Let me get a couple super chats, and then we'll get into the actual text of the opinions. Britt Cormier says, my hate for all of LawTube continues to grow with every video. Good thing, you guys and gals, there is no vax for the disease that makes me give money to YouTubers I hate. When will Big Pharma come to my rescue? I appreciate it. Thank you, Britt. I love it. I please pass this disease on to others.
Well, I feel you, man. My hate for the LawTube also grows.
I hear you, brother.
Oh, good times.
Becky Maynard says, are the decisions of the Supreme Court final, or are they stays, specifically the OSHA mandate? So
it's a stay. Well, yeah, because it's an injunction. It's a ruling on the preliminary injunction. So strictly speaking, you could have further proceedings on the merits of the decision at the level below. And so theoretically speaking, you could at some point in the future have a decision that would overturn the preliminary injunction based on a fuller reading, because whether or not preliminary injunction issues or not, or permanent injunction issues or not, are different questions. So yeah, you could have further proceedings, but I think that's probably very unlikely as a practical matter.
Yeah, but don't forget, this is just to keep the status quo as it is now while you go through the factual findings. So, nobody's really won now. It's just like, you can't do this until we get a factual finding.
That's what I just said.
Yeah, so.
I
want to make it clear, but you're right.
Extra crystal clear.
Okay.
Brian Hoffman, thank you for your super chat. And I think here's another one. Brian Hoffman wants to know, does the Nuremberg Code have force in the USA on this issue? I don't think so. To be honest, I haven't looked much at the Nuremberg Code, but I don't know. I may have to look into that and get back to you on that. I don't know. Have you guys looked into the Nuremberg Code on forced vaccinations?
No.
Although, I mean, I would say that both of these rules, I mean, it technically is not like, get vaccinated or die, right? There technically is a choice, although it's not much of a choice, right? Like the idea of either get the juice or be fired, essentially, is what it is for in either case. Although I saw some people on Twitter saying, no, that's not really it. It's either, get the juice or come in for weekly testing, which is like, oh, okay. Yeah. Just pay $200 every single week just so you can go to your job. That's great. That's not much of a choice. Thank you very much. Did you not see the Matrix Resurrections? I wish I had.
It is a choice, and people are quitting their jobs to reflect this as a choice. As I think we're well aware from the whole Great Resignation thing, people are quitting their jobs for all kinds of reasons. So the idea that individuals don't have choice in the system, I think, has been belied by the recent history, which shows people do have choice. the employment situation is one of mutual consent. Either side can request any conditions they want, and if there's an impasse, either side can walk away. And there's been this idea that employees are on the short end of the stick, but if you go look around, employers are looking for people, can't find them. So at the moment, it seems that, employees really do have the upper hand at the moment in terms of insisting on various conditions that they want. So people are walking away, people can walk away. It's not,
Yeah. I mean, there also is the great resignation going on right now these days too. So that's an interesting wrinkle to this whole conversation also.
Yeah.
Bipolar Punch says a cruise ship of vaccinated only had a major COVID outbreak. Vaccines are not working. I mean, I will just say to fly back home overseas, turns out all I needed was my Vax card. So when I personally had COVID and had to stay in the States because I did a PCR test before flying out, if I hadn't done that PCR test just to, cover my bases for travel, because I wasn't sure exactly what the standards were for getting back and I didn't want to get stuck on my international layover. If I hadn't done that, I could have flown all the way home while being COVID positive and not knowing it. So, and I could have spread it to everybody on all of the planes that I was on and during my layovers. So
at this point, everyone's
that was a huge
COVID.
realization for me.
Everyone understands this, right?
Yeah, it's like the flu,
right?
It's going to be
spread, and even the N95 masks don't seem to work that well for the more recent variants. So everyone's getting COVID. So
this is according to trusted authorities. YouTube gods.
I think the right word is endemic. I believe is the right word for it. Yeah. It's endemic at this point. So suck it up and let's move on.
Pandemic to what is it? Endemic.
Yes.
No.
Okay. So John O'Brien says, Kurt, I love you. Your take on this is wrong.
No.
If this is even a close call. If a state can do this under Jacobson, it's a signpost that the feds can't.
No. They're totally different questions.
Police powers of the state versus, because the federal government is a government of limited authority, so they have to be given the authority to do something where the states are able to do anything virtually.
Your take is wrong. Just whether they're different questions, they're totally different questions. Whether or not states can do things and whether or not federal governments can do things are entirely different questions. They have different kinds of authority under different bases. The states have what we refer to as police power, which I think our friend referred to as a police state, which I'm not sure if that was a slip of the tongue or not. But yeah, police powers are different than police state. Police power is the general power to do stuff. The federal government doesn't have police power. They don't have the general power to do stuff. They have enumerated powers to do stuff. But those powers can overlap. And they sometimes do overlap, not for the least of reasons, because, the United States Supreme Court somewhat famously in Wickard v. Filburn said, hey, all the things are interstate commerce, so why not? So we've stretched that out to all understanding. But yeah, they're totally separate questions. To say whether or not the state can do it and whether the federal government does, they're totally different questions. And this, no.
So, and then I think this is the last one. Z. Michael Gelka says the EUA mandates violate Nuremberg. If you destroy someone's life, it's coercive. Be honest. But Nuremberg only has force at bullet point, not by law. And I think that's the last one. Let me just make sure I'm all caught up. So
it doesn't violate Nuremberg. And this is, again, stretching things beyond all rationales. It's actually slightly annoying how much they're stretching things with human rights issues and Nuremberg issues. These things were meant to deal with the war crimes of the Nazis and the experimentations that they were doing on helpless prisoners and Mangala and all that kind of crap that was going on at the time. The Nuremberg Code was not contemplating Pfizer and coming out with a new vaccine, and it was not contemplating any of this stuff. You're taking principles and you're stretching them beyond all. It's a little bit like saying that everything is Nazi, or everything is it's a little bit annoying. I
agree. By the way, Kurt, I totally agree with you. It's a little bit like saying that OSHA trying to stop these toxins in the air, that's why they're allowed to do this, because toxins in the air is really reference to asbestos. And so if the court is taking such ridiculous stretches, you can't really fault lay people for trying to take similar stretches. But I agree with you that both are taking bizarre stretches in the way that.
Well, I have no problem beating up the U.S. Supreme Court too for being idiots when it's appropriate. I do that all the time.
Fair enough.
100,000 babies on ventilators, right?
Yeah, no, I can beat up the Supreme Court too.
Yeah.
No, this is stupid. I have no problem calling the Supreme Court stupid. I do it sometimes. Like, this is stupid. This is stupid. This is stupid.
Do you know?
But hold on, Joe. I got something for you though. You were actually 100% correct. She did try to clear it up, but going onto the official CDC site, they have removed something very particularized to add to your point. So I got to eat crow. I'm going to share the screen. You were correct. Right. I was actually wrong. So
Thank you.
Share it.
Thank you.
Well, you know me, but if I'm wrong,
I know. You don't hesitate to me when you're mistaken.
Yeah. So I'm going to share it.
I hate the chat right now, by the way. I just like to be noted for the record. I'm reading the chat, which is always a mistake, and I hate you all.
It's mostly uninformed, or it's informed but angry at you. All right. So this is the most updated piece for the CDC. This is the updated website. And now, here is what they're saying about the vaccines, the tools to fight Omicron. Now, look at this sentence. This has been changed. The COVID vaccines are highly effective against preventing severe illness, hospitalizations, and death. Scientists currently investigating Omicron, including how protected fully vaccinated people are against infection, hospitalization, and death. So, Joe, you are correct. They are saying it's still an open question whether, if you are vaccinated, whether it is against, and whether you're more protected against infection. So, I must do a mea culpa. You are correct. That is an open question, and the CDC says it's an open question, but it does reduce hospitalization and death. So you are correct.
Good find.
Boom. Nice.
Yeah, according to the numbers, it depends on age demographics, but even in the worst case, I believe that the vaccine reduces the risk of death by 5 to 1 in the worst age demographics, and it gets better from there.
Yeah.
I believe it's for the elderly. It's at 5 to 1. But man, I'll tell you what, if you're going to reduce my risk of dying to 20%, I figure that's, that also, this is a slight point of annoyance when people say it's not a vaccine because it doesn't work 100%. No vaccine in the history of time has worked 100%. Various vaccines work to varying degrees of success. And to say, well, this is a vaccine and it works, 60% of the time, it's like, hey, 60% of the time is better than the 0 I started with. I'll take it, as long as, of course, it doesn't have, the counter effects. But you give me a vaccine that works 10% of the time, and it doesn't have serious counter effects. And I'm like, hey, 10% was better than the 0.
Yeah.
I'll take my 10%. I'll take it every day of the week. What are you talking about?
And everybody universally says the flu vaccine is worse, right? The flu vaccine is worse than this universally, and nobody ever not calls it a vaccine. So so a lot of these arguments are just frivolous.
and keep in mind too that for all of these other vaccines, I mean, part of the reason why every kid is required to get it in order to go, into school, for public schooling, is because of the fact that part of the efficacy of these vaccines is they're not 100%, but what helps boost their efficacy is the fact that everyone around them is vaccinated too. That's what herd immunity is that everybody has this, and that's why when you started to see these measles outbreaks at places like Disneyland.
It looks like herd immunity isn't really a thing at this point, because herd immunity really speaks to the idea of, I think, transmission, or maybe I'm misunderstanding herd immunity, but that's how I always parse it.
You're right.
Herd immunity, the idea that because enough people are vaccinated or otherwise have the disease, that the vaccine can't spread anymore, referring to herd immunity. So that doesn't seem to be a thing, because even in places that are now on their 4th shot and have extremely high rates of vaccination, transmission doesn't seem to be impacted. Yeah. So at least for the new variants, Pfizer says they're coming out with one in March to deal with some of the stuff, but that's a future and speculative. But I don't think that reducing or eliminating transmission necessarily is what makes or breaks a vaccine.
Right.
Again, if you're going to give me something and say, hey, this is not going to prevent transmission at all, but you know what it's going to do? It's going to reduce your risk of dying to 1 in 5. It's not going to prevent you from getting the disease, but it'll prevent you from going to the hospital and dying.
Right.
With an 80% success rate. I'm like, hey, that sounded pretty good to me, man.
And I'm going to say, I feel like the chat's going to get mad at me for talking about this, because I am vaccinated.
That gets mad at everything.
That was one of the things that I really took into consideration, was the fact that I'm overseas. There's a different healthcare system here. I don't exactly want to be hospitalized where I'm at. So if there's something that, maybe I get the bug, but the symptoms are far less because of the fact that I've gotten the juice, that for me was plenty of consideration for getting it, for getting both the first round, the second round, and then the booster. So I mean, now moving forward, I don't know about further boosters. Each one requires its own consideration, but that was what it was for me personally. So
And by the way,
that was
since
not
I
a
think
new
this
thing.
point
This
has-
was months
since
and
this
months and
point-
months ago.
Since this point, I think, has gotten lost at this point, everyone does understand that I was against the CDC, or apologize, against the OSHA mandates. Everyone understands this, right? I thought it was excessive.
You're a
of
glowy.
OSHA's
You're a
authority.
glowy.
We all were. No, we
Yeah,
all were.
no,
but
like,
the fact
because,
of the matter is, people
I
will
think
all
people
say that we're all
lost this point. That I had disagreements with the majority opinion, as Nick and I had a little bit of a friendly discussion about it yesterday, right? So some of the arguments from the majority I didn't find particularly persuasive. The one that did it for me was that what OSHA was trying to do impacts you outside the workplace. So they're trying. Well, first of all, they're doing two things that are a problem. One, they want you to change physically something about yourself, so that's a problem. That's different. But even perhaps even more to the point, what they're wanting you to do would impact you outside the workplace, which is unlike any other mandate, right? If they want you to wear a hard hat or a high-vis jacket or install a railing or any other numerous things that OSHA might require inside the workplace, to me, whether or not that threat exists inside or outside the workplace exclusively is irrelevant. That's a point of disagreement, right? So the threat might exist in the whole wide world, but if the threat does exist in the workplace and OSHA can mitigate that, then I think that's within in their domain. So that was a point of disagreement between me and the majority and also Nick. But for me, what did it was they're requiring you to do something that would impact you outside the workplace where OSHA's authority ends. They don't have authority outside the workplace. And they want me to do something that's permanent outside the workplace. And I'm like, that goes too far. So I opposed the OSHA mandates for, jurisprudential reasons. So in case that got lost somehow.
Kurt, I just want to point out, you're framing there reducing the risk of death from 100% to 90% is worthwhile. I think that's really a little bit of improper framing because, let's assume, I would agree with you. Like, let's assume someone, God forbid, had cancer. And it's like almost it's a terrible type of cancer, and 80% of the people who get this cancer die. And you can give them a drug which says, well, that's going to reduce your number from 80% to 70%. They will run and pay thousands of dollars to get that drug. I agree with you on that. And they'll say, even if it's a trial drug, give it to me. That's what they'll say. But when you're talking about something which, in theory, like 0.3% die, and you say, I'm going to reduce the chance of that happening by 20%, or 50% even, and now it's going to be reduced from 0.03 to 0.15, and people are much less inclined to say, I'm going to grab that.
This is fair. This is fair. I did screw up this point, and someone in chat actually made a good point correcting me. Yeah, because I was saying, it reduces you from 100% to 20%. This was a fail on my part. So that was a fail because we didn't start at 100%. We started at whatever fraction of less than 1%. So we reduced our risk from, let's say, 0.3 to whatever 80%, to whatever 20% of 0.3 is. So we reduced our risk from 3 in 1,000 to 3 in 10,000 or something. Which fair enough.
But I do want to. But just so we understand, when they say efficacy, they do mean more than just one thing. They don't just mean death, right? It's death, hospitalizations, severe disease. Right. Yes, so, Joe, even if I accept your point on death, which I accept, right? On the 0.3% for death, 0.3% of the people. But there's also the hospitalization piece, which everyone, all the data that you can watch can say, yes, you are orders of magnitude less likely to be hospitalized if you get vaccinated, and you are orders of magnitude of less likely to die. So even if you're right, the transmission piece, that's only one leg of the three-legged table, right? Now, don't get me wrong. Now some people say, well, that makes the table fall over. Some people say, well, those other two are just as important enough. So I can agree that, yes, transmissions may be bad, but the other two, I think, are well enough where you can still say these things are effective in reducing hospitalizations and reducing death on orders of magnitude.
Right. And I do want to point out that the implications of being hospitalized too are that, number one, you can get other diseases that tend to spread around the hospital, meaning, you could get You could get strep, you could get staph, you could get all kinds of things. You can get, if you're out and on off your feet for that entire time, you can start to get blood clots, which I know is a thing with COVID generally speaking anyway. But like there are more things that can come up just because of being hospitalized, which is terribly ironic, right? Because you're there to get healthy, but there are so many more risks that come up through the process of hospitalization. So these are very real issues, not just like for the sake of the numbers. Like there are things that come with that. So let me get through some more super chats because we got a bunch more. Every time I'm like, I think, all right, we're caught up. Let's get to the opinions then, and then we get into discussion, and more people want to engage. And it's great, it's wonderful. But
this is great.
Let me get through. Furby Slayer says, "Isn't the less symptoms part more risky for healthcare spread in reality? Kurt, choice isn't valid definition when it's because of coercive force."
Well,
you might have a different definition of coercive.
Yeah, but just to be just to be clear too, the Supreme Court, when we go through the opinions, they make the comparison to other vaccines, right? They're saying this vaccine, like all other vaccines. So the healthcare industry, they've been mandated to take many other vaccines. Yeah. And they have their bodies are filled with vaccines, even the flu vaccine. So now that argument doesn't fly. Say, well, they shouldn't be. Well, they were ordered to take all these other vaccines for decades.
Yeah. John O'Brien says, "Kurt, I will start a YouTube channel. Debate me." I've never heard
John
of
John is good though. Be careful with John. John's an attorney, and he is good as hell. That's what he's been
talking for a while about starting a YouTube channel, right? Like, just start it already.
He's good. John is.
If you want to pop on a stream with me, John, send me a DM on Twitter or something. Maybe we can.
John is a fantastic attorney. He is really good.
Okay, I respect
be
that.
Careful.
I respect having an intelligent discussion with someone who is intelligent and can offer intelligent commentary, because there's also the possibility I could be wrong. And,
always.
And like I made a mistake earlier, and Joe made a point. I'm like, yep, got that one wrong. That was a fail. So that way I will be smarter. Yay.
Yeah, always a win, right? And the other one is I got the super chat, so I'm very happy about that. Z Michael Gelka says, "It absolutely violates Nuremberg. Read the document on your stream and stop lying to support abuses by Fauci." If we can get to it, I've got the other opinions that I want to do first. Maybe we'll do a separate stream that's specifically talking about the Nuremberg Code, because I think that might be something that would potentially warrant its own individual discussion.
In the chat, that'll be fine.
You what?
Yeah, you can cover it, and I'll just rage in the chat the whole time. That'll be fine.
Cherokee Girl says, "For Indy, give her scratches. Missed seeing her." I know, I did too. Here she is. Oh, you guys, she's sleeping so hard, her tongue is sticking out. It's great. It's
for a super chat of $50, I will debate you on my channel. On my channel, you have to give me $50. My PayPal link is paypal.com/uncivillaw.
Oh, there you go. Anti-Commie says, "As an uncivilized, I must defend Kurt's honor. He is actually well-reasoned in his opinions. Listen to him and find out." I agree.
Feel a little beat up. Thank you. Appreciate the love.
I completely agree. I do. This is why I love having you guys on this channel. The conversations are always great. They're always very well reasoned and very passionate. Z Michael Gelka says, "Gauntlet down. Let's debate on stream why Kurt is wrong and EUAs violate Nuremberg." So I think there might need to be a special live stream dedicated to this discussion. Britt Cormier says, "Nate, you are correct. It is better than the flu shot. However, I have never had a job say, 'Did you get a flu shot this year?' If not, we will test you for the flu every week at cost to you." And that's the difference between the OSHA decision and the CMS decision, because hospitals have required that because of the fact that they are surrounded by vulnerable people. They routinely require healthcare workers to get the flu shot in addition to all of these other big ones. But that is a distinction between that one and the OSHA one, because other non-healthcare workers typically don't require that.
Exactly.
Which by the way, that element to it, and this I want to make clear. If they were mandating an N95 mask, I would say, look, I don't believe the federal government should have this power, but if you're going to grant them this power, that at least is stopping transmission. That makes sense to me. I can't debate that. That's a fair point.
And it's something you can take off after work.
Yeah, it's something you take off after work.
They made that
I don't understand since even being vaccinated is not going to stop transmission. Why are you only testing the unvaccinated? If you want to say we should test people, test everyone. Okay, fine, test everyone, and anyone who's sick, don't let them come to work. That would make sense to me also. But since the getting vaccinated is not going to stop you from transmitting it, why would we only test the vaccinated? How is that helping stop the spread of COVID? I don't understand that at all.
With the revelations about Omicron, that especially is a good point. I think that they probably just looked at the reality of testing, the previous data, but also I think the reality of, I mean, it makes most sense to just have a policy that says everybody needs to be tested, and if you test positive, stay home. You're not supposed to come in. But the reality of the fact is that there's a cost to all of those tests, and then there's a question of who's going to bear those costs, and then there's also the question of are these tests actually going to be available? Because of course there's been a massive unavailability of tests during this whole Omicron flood, you could say, and there have been at various times during this pandemic. And really, anytime we've had a new strain kind of show up and start to wreak havoc, I should say. Havoc. But the reality there is I think a cost and an availability issue there. And so, but I mean, in an ideal world, yeah, that is the policy that would make the most sense, is just to say, test everybody all the time before they come in, and that's it.
I know some people are saying in the chat, masks do nothing. The N95 masks supposedly do something. The other, I agree, the cloth masks do nothing. But the N95 masks, if you want to mandate that, everyone has to wear N95 masks.
They keep me warm on my morning runs when it's cold out.
That's true, yeah, but they're bad though. The cloth masks.
That's the only reason why I would wear it during your run.
Or you're not going to wear those masks that restrict oxygen flow so you can train like you're at higher altitudes.
I mean, that's actually that actually is quite a good strategy. If you're training for a marathon, which I kind of sort of am at this point, because of my running challenge, which I'm thinking of having a separate video where I'm going to talk about exactly what my plan is for
I'll
all
run
of
a yard
meeting
for
my
every
running
1,000
challenges.
subscribers.
Hey,
I owe
there
you 50
go.
yards.
General says, Nate, Fazy's here. Glad to see you on the stream. You are my favorite law tubers. And I specifically read this when Nate went away. No, I'm just kidding. But hopefully he comes back and we can tell him about this. But I'm sure he probably saw it during when it originally popped up. Thank you for the super chat. Jim Satala says, how does Kurt square his support for mandates and his opposition to states limiting baby murder? You don't have to go too in depth into this one if you don't want to, because I know it's kind of getting a little bit off track for this discussion.
I think I might be being trolled at this point.
Could be. That's also a very distinct possibility. All right.
Good.
Well, we can defer to later. All right.
I'm good.
All right. Naughty one says, when will the issue of refusing to provide proven treatments, which could have prevented a large number of deaths, be addressed? I mean, are you talking about like treatments for people that are actually sick, like monoclonal antibodies, that kind of stuff?
Horse paste.
Oh, that kind of stuff. I don't know. I mean, it's not a part of either of these lawsuits. The Supreme Court didn't talk about it, so I mean, we're not gonna. We don't really have much reason to address it here for the purposes of discussing the law. But I know that there's a lot of people that want to talk about that kind of thing, and it's a very important issue to a lot of people because it's. I mean, when people get sick, we want to make. Exactly. Good one, Joe. A long story short says, but this isn't a vax, it's a therapeutic. It is therapeutic. Vaccines prevent infection. The shot actually increases transmission. I think we discussed that earlier.
I don't think it increases transmission.
Yeah, I don't think so either. I haven't seen any data to suggest that anyways, is how I'll say
If it
that.
increases transmission, that would definitely change the analysis.
Yes. Z Michael Gelka says, I'll pay you $100 at the end of the debate. Let's go.
All kidding aside, you can't live stream from your channel unless you have 1,000 subs. There's no capacity to do it. So if you have 1,000 subs, it can become a serious offer. But unless you have 1,000 subs, yeah, you can't live stream. So
I'll stream with people on my channel. Yeah,
there you go. Meatflower66 says everyone's risk is different. Seems like you're lumping everyone in an overall percentage. I'll pass on the jab based on my risks and natural immunity.
If you're a soft sit, though, I'm going to have to massively increase the prices for my own sanity. And yes, you can pay me in silver. That's fine.
If you bring up the Nuremberg code, he's going to charge double.
But to respond to the super chat, I mean, I definitely understand that a lot of people that have different risk tolerances. I mean, I just in talking to friends and family of mine during the last couple months, talking about getting together with family and friends and all that kind of stuff. I mean, that was immediately apparent to me that there are some people that are like, don't make me wear a mask ever again, ever. I don't care who has it. Give me the disease. I'll get it and get natural immunity. I don't care. And then I have other people that are quite very much afraid of getting it because of one reason or another. So
you're going to get it at this point. There's just you're going to get it.
Despite the evidence to the contrary, in order to make sure there's no COVID misinformation out there, there's tons of evidence about this, but it's not proven that getting a booster shot actually makes you an asshole. So it probably does not. It's probably no correlation there at all. There's no. So
how many booster shots have you had then?
There's probably. I said there's no causal effect. There might be a correlation, but there's no causal effect. So just throwing that out there. Just saying.
Excuse me.
It took you a second there.
I got there though. I got there.
So Richard blah blah blah. If I had every once in a while, I really just trip over my words here. Richard McCarthy says, "Hang on, vaccine reduces seriousness of symptoms. Symptoms include coughing and spluttering, sneezing, etc. These symptoms are also the way COVID spreads. Of course, vaccine reduces spread. Come on." So, but it doesn't mean that you are that you're not going to get it and that you're not going to spread it at all if you get it. If you're vaccinated, because let's say you do have it, it's in your saliva, it's in your tears. If let's say your nose itches and you pick your nose and then you touch the door handle, that's a way that can spread, even if it's much more limited than coughing, openly into a room. I understand that, but to say that it reduces spread is different than saying that it eliminates the spread, right? So I think that's an important distinction. Andy the Game Maker, hey, welcome back to another live stream. He was watching earlier too. Did we talk about the NCAA's new rule that includes natural immunity to define fully vaccinated? We didn't talk about that, but I did see that. That was like a few weeks ago, wasn't it? I thought that was really interesting, but I didn't see any of the nuances of that rule to see if that lasts for a particular time, like 90 days. Because I know that the CDC has said that the natural immunity is supposed to last for about 90 days, supposedly.
Is that based on anything, or did they pull that number out of their ass? I mean, just out of curiosity.
Oh, I don't know. I have no idea how the CDC
is it based on the science? Is it based on the Fauci? Who somehow apparently is getting paid more than the president of the United States. This is something I learned recently through through testimony. I didn't even know that was possible. I thought everyone was capped out at the president's salary, but apparently Fauci is making more than the president of the United States.
I mean, he's been in the job for however many decades at this point.
Yeah.
No president can be in the job for.
And then he said,
decade.
yeah, he said all my financial disclosures are public. Spoiler alert, they're not. People have been trying to get him under FOIA, and no. So, Fauci may have once again perhaps told a lie to the Senate again, possibly, maybe. Yeah.
All right. Let me get this. Let me get this.
How many ways can I
here.
demonetize your channel over here, Legalbytes?
And one more super chat. Jim Satala says, "We are lucky that it doesn't spread by bootlicking." That's great. Okay, so I'm actually going to change I usually do this 2-page scrolling, but because of the way that this is showing up, I'm going to change that. Okay.
There you go.
Yep, that one, and we're going to do it for this one too.
Now, this is just by way of, in case you want to know why these margins are the way they are, it's because the Supreme Court's official paper is this weird margin. I have to go look up the official rules, but it's a weird paper margin that no one else uses. So obviously this is written on 8.5 by 11, but that's not the official paper. So this would look better if it was printed in the official booklets, which are like 5 1/8 by 7
like a pamphlet
3/16 or some bullshit size that no one uses.
Exactly. So I've got both of these pulled up here. This one is the OSHA opinion, and this one is the CMS opinion. We'll go through the OSHA one first, and then we'll go through the CMS one. But because I think it's important to actually look at the text so that we can look at the reasoning behind the ultimate decision that they made. So for this one, we can kind of skip ahead just a little bit. Do you guys have anything to say before we jump into it, or is that a mistake for me to ask that?
OSHA can suck me.
You see, it was a mistake. It was a mistake.
It was a mistake. All right. So the Supreme Court says Congress enacted the Occupational Safety and Health Act in 1970. Excuse me. The act created the Occupational Safety and Health Administration, or OSHA, which is part of the Department of Labor and under the supervision of its secretary. As its name suggests, OSHA is tasked with ensuring occupational safety, that is, safe and healthful working conditions. It does so by enforcing occupational safety and health standards promulgated by the secretary. Such standards must be reasonably necessary or appropriate to provide safe or healthful employment. Sorry, I got distracted. They must also be developed using a rigorous process that includes notice, comment, and an opportunity for a public hearing. So this is getting into the two main points here in both of these opinions. The court is having to answer two questions. Number one, is this rule within the scope of the powers of this particular federal agency? Is this something that they even are allowed to do? Because, as we discussed earlier, there's a difference between state police powers and federal powers, right? In order for a federal agency to be able to do something, to issue any kind of a rule, any kind of a regulation, any kind of restriction on people, or on businesses, or on really anything, to do anything, they have that action that they want to do has to come from the act that actually created that agency in the first place. So if it's outside the scope, then that's not something that they're allowed to do. If it's inside the scope, it is something that they are allowed to do. Now, that is not the end of the analysis. Number two is that they have to show that they came to that rule through the proper processes. So there's a notice and comment period that normally has to follow for any of these rules to take place. There is an exception, which is an emergency exception, which is discussed in both of these cases because of the fact that, we're talking about COVID, we're talking about a pandemic, we're talking about, health issues and whatnot. So the question was whether in this particular situation, this was a situation where the secretary of that agency was proper in using that emergency exception to that notice and comment period. Anything you guys want to add to that? No. Okay, cool. So and another point that I really want to make as we're going through the opinion is the fact that the Supreme Court has certain guardrails in reaching the conclusions that they reach, right? They're not a trial court. They're not going to be coming to certain specific factual conclusions. Of course, yes, they are going to be using facts in their analysis. They're going to be using certain conclusions that have been brought to them. They're going to reason between certain things, but they can only do so to a certain extent. And they have certain rules, where they know that they have certain areas of expertise and they don't have certain areas of expertise. So areas of expertise that they do have are going to be issues of the law, that's where they're going to say, we know better than you guys do. But where there's a situation of public health, for example, the Supreme Court justices know that they're not doctors. They know that they are not the experts in this area. So they are, generally speaking, going to be deferring to an agency that is talking about these kinds of health issues where there is a very nuanced factual dispute. So, we were talking a lot about, whether the vaccine is effective against Omicron versus these other variants and whatnot. The Supreme Court was never going to get into a very nuanced discussion about whether or not, that even matters in this case, because they're not the ones that are triers of fact in this case. They're not finders of fact. They're not the ones that are going to be saying, this matters because, the Omicron variant is, more powerful over the vaccine. It doesn't really matter because, but if we were talking about the Delta variant, it would matter. That's not something that really enters into their reasoning. So,
which is unfortunate, because I'm not saying that they should be going. I agree that they should not be a trier of fact. But every time you're deciding a case, there are certain basic facts that you can take judicial notice of, and if it's an admission by one party, you would think that would be something that they should be taking judicial notice of.
But judicial notice typically is going to be something that is like there's absolutely no dispute. I mean, courts do take judicial notice, but it's usually going to be, on, let's say you've got a murder case and we're talking about, there's an issue in the case about whether or not something was visible to someone. And so courts might take judicial notice of the exact time of sunset on a particular date when the murder happened. That's an example of.
You're right. It's not judicial notice. You're correct. That's not the correct. It's important to use proper nomenclature. It's not judicial notice. What I'm saying is, when you're listening to what the government is saying, and the government is saying a lot. When you listen to the government is saying, it's important not just to listen to the results that they say, but the logic that they're saying also. Listen to everything they say and give them every benefit of the doubt. You want to say, look, they have thousands of researchers who spent hundreds of thousands of hours studying this, and they know more than we do. That's logical. That makes sense to me, because they obviously have. They have scientists who have far greater expertise in these areas. Of course, they're going to defer. I'm simply saying, at least listen to everything they're saying and weigh whether or not the conclusions they're reaching are actually based on the evidence, on their own claims, whether the conclusion as to how this will help is logical based on what they're saying their studies have shown. So believe them on what the studies have shown, and then just assess whether or not their conclusions as to how this will help are actually logic based or agenda driven.
Isn't that a fact question? Because that's all right. So just so, Joe, I think you're right in part, but then I think you're wrong at this part part of the procedure. So this is coming up from a injunction that was placed against OSHA, right? That was lifted by the Sixth Circuit. So you had an injunction that was lifted. So we're at the point. So at the point of this, the facts haven't been flushed out. So you may be correct, right? But the facts haven't been flushed out. So right now they're trying to decide whether the injunction should keep in place, not whether the actual factual arguments on the underlying claims are actually correct. You know what I mean? So that's kind of where we're at right now.
That's why I say give every benefit of the doubt to what they're saying. And treat it like a summary judgment motion. Give them every benefit of the doubt to what they're saying. Assume every factual claim they're talking about as to what the science shows is correct. Every single element of it. And then just say, once we know what your science that you've concluded says, does the step you're saying we should take make logical sense or not? That's not actually weighing into anything.
Joe,
that's basically saying, is your logic logical?
Joe, but the fact of the matter is, during oral arguments, I'm not sure if you watched it with us, but during oral arguments, right? The non-moving party, right, which was the government, came out and said vaccines are effective. They will lose. They said all these things, right?
Right.
So now, if they're saying all these things in their pleadings, you have to, because the place we're at, accept their conclusions and give them all favorable inferences, right? So that's what the court did. I say, all right, we're going to agree vaccines are effective. Vaccines stop transmission, right? Because that's what they said in their arguments. That's what they said in their briefs. Now you're coming and saying, well, they just said this 2 days ago, but that wasn't the people who were actually arguing in the case. So even if I agree with the proposition that you're saying, the CDC director made this thing, but in the case, in the argument, and the stuff that they have in front of them, they can only say, okay, we got to give these arguments favorable inferences. So yes, the vaccines are good. So just so everybody understands, this case, the vaccines are good. It is not, they are effective. That is how the Supreme Court is looking at vaccines when coming to these conclusions.
What about, so let me ask you this then. I mean, I'm not sure, does the Supreme Court ever have a motion to renew based on new evidence that has been presented by the CDC?
So that's
and
why they sent it. That's why in this case they sent it back down to the lower court for fact finding to determine if these things are flushed out. So that's what I say. So right now we're going to enjoin the federal government from putting this in place because we don't believe they're right on the law, but also we want the facts to be determined whether this thing is even effective or not. So that's where we're at. So what you're saying could be correct.
Well done.
Yeah. All right. A couple super chats and then we'll get back to it. MC says, great content. Thank you so much. Renal Ryan says, if you're going to test everyone. People get COVID regardless of vax status. What happens to all the people who test positive that are asymptomatic? What happens to businesses when they lose half their workforces? We talked about that earlier, that would technically be the most logical policy to have. Logical. Havoc. Logical. There we go. I'm adopting all of these different accents, which is actually a thing that I have unconsciously done many times before, and it's hilarious every time it happens. So yeah.
I just came back. I'm just looking at the chat. It's so funny because people, I think people want to believe, it's so hard dealing with radicals because on one side, whenever you just lay out the pure facts of the situation, people hate you. Hey, oh my God, the fact that if they don't go with their side. There's just so many people in the chat who just hate the facts. Everything I just said about the posture of the case and the Supreme Court's understanding of where vaccines are at now and the arguments are all factual, right? Joe, this is not something that's crazy. So understanding it in that posture I'm not saying that everything this is correct. I'm not saying the vaccines are even effective. I'm saying under the posture of this case, this is how they're being evaluated. So, there's like people just don't understand this. I don't understand because they don't agree. They don't, facts are a bad thing.
Alita, I gotta fly. So I'm just gonna. I appreciate you bringing me on here, Nate, Kurt. It's always phenomenal seeing you guys. Peace out. And I didn't text you, but I will, Nate. So we'll be in touch.
All right, definitely, brother. Definitely.
Take care, brother.
See ya.
Have a great weekend.
Yeah, you too. So I was just about to say that it's if you guys have watched a lot of our videos when we've been talking about motions to dismiss, I feel like we talk about that particular motion a lot at least on my channel. But when we talk about a motion to dismiss, the court assumes the facts that were pled in the complaint as true. We're not talking about whether or not it's true. We're talking about whether or not there are enough facts to check all of the boxes in order for that complaint to be plausible, right? To be legally plausible under some legal theory, right? So it's kind of similar here. There are different stages at which the court at various levels, from the trial court all the way through the Supreme Court, is going to make certain assumptions about the facts, depending on what question is before them, what sort of procedural process we're talking about, that kind of thing. And that is exactly what Nate is talking about here. So this is not the court endorsing vaccines. This is not the court, making any kind of a statement about whether they're good, whether they're bad, whether, they create 10 heads to pop out of your neck, like they're not, there's nothing that they are saying about the vaccines themselves. They are assuming those facts just because of the procedural status of this case. So, all right, cool. So turning back to the opinion. So the court said on September 9th, 2021, President Biden announced a new plan to require more Americans to be vaccinated. Remarks on the COVID-19 response and national vaccine. Oh, sorry. That's a citation. Excuse me. I'm used to them being, I always prefer when citations are italicized because it's so much easier when you're reading them out loud.
They don't do it here too. Yeah, it's so much easier.
It is. So as part of that plan, the president said that the Department of Labor would issue an emergency rule requiring all employers with at least 100 employees to ensure their workforces are fully vaccinated or show a negative test at least once a week. The purpose of the rule was to increase vaccination rates at businesses all across America. In tandem with other planned regulations, the administration's goal was to impose vaccine requirements on about 100 million Americans, 2/3 of all workers.
Now, I do want to stop this and say, reading through this, this is the Supreme Court cutting through the BS, right? Because if you listen to the liberal shows now, I go on both sides. So if you go listen to the liberal shows, they're saying, well, this was a testing mandate. Oh my God, this is not a vaccine thing, and that's just not true, right? This was a workaround, and we all know it. And Biden essentially said it. So when you hear like the news media go around and start trying to pretend like this was not a vaccine mandate, they're not being honest with the facts, right? This was obviously a vaccine mandate, and the court is pointing it out. This is obviously a vaccine mandate, and we need to stop trying to coach it as if it was not a vaccine mandate, a testing mandate. So what they've just said is this is vaccine mandate with a test with a testing opt out. So they've literally taken it and reversed it. It's a vaccine mandate with a testing opt out.
Yes. And that's a very important point. And that's why we like to read the actual opinions on these, not someone else's interpretation of these opinions, because you can read it one way or another, but seeing it for yourself, it's like the hearsay rule, right? When you're at trial, you're not allowed to let in testimony that is actually hearsay unless it falls under a particular exception. So, one super chat that just came in. Phil James 1 says, Nate, great explanation. I had a good logic view and gave me an understanding of it. All right. Nice.
Oh, thanks. I appreciate it.
Yeah. So with that, after a 2-month delay, the Secretary of Labor issued the promised emergency standard. Consistent with President Biden's announcement, the rule applies to all who work for employers with 100 or more employees. There are narrow exemptions for employees who work remotely 100% of the time or who work exclusively outdoors, but those exemptions are largely illusory. So this is a very important point. And I think, you'll see that there's a difference between this rule and the CMS rule, because the CMS rule has certain exemptions that are that were written into it. So you can't really say that it's particularly, whatever, you can say that it's particularly strict, but there's much more room for people to maintain their jobs and not get the vaccination under the CMS rule than there is under the OSHA rule here.
Yeah, and I think also too, it's also about being specific to certain environments too, because that's essentially what they're saying. They're saying, this doesn't really give anybody any options, and it pretends to give people options, but that's all really illusory. It's all BS, right?
Yes.
If it's either get vaccinated or lose your job, and the court is saying we're not ready to go there yet. So I like the way they've explained the background, because I think this is an honest understanding of what the Biden administration was trying to do, and kind of cuts through the nonsense of what they were actually arguing in court. So because that's what they're saying. We don't believe what the Biden administration was saying. This is a vaccine mandate with a testing opt out, and there was really no exemptions here.
Exactly. The secretary has estimated, for example, that only 9% of landscapers and groundskeepers qualify as working exclusively outside. The regulation otherwise operates as a blunt instrument. It draws no distinctions based on industry or risk of exposure to COVID-19. Ding, ding, ding. This should start to make some alarm bells for the other one.
Yeah, like, oh my God.
Flag number 1. Thus, most lifeguards and linemen face the same regulations as do medics and meat packers. OSHA estimates that 84.2 million employees are subject to this mandate. Covered employers must develop, implement, and enforce a mandatory COVID-19 vaccination policy. The employer must verify the vaccination status of each employee and maintain proof of it. Ugh, that's a lot of paperwork. That's a lot of.
What this is for those of you who don't speak Supreme Court, they're saying this is a tax. This is an underlying tax, and this tax, these are the things that you're going to be the cost. The cost 1 is you got to keep all this paperwork. Cost 2, you got to and in cost 3, you got to get people vaccinated. So this is actually under a backdoor way to tax businesses to force them to vaccinate their employees.
Yeah, that's a good point. Really good point. I'm glad you pointed that out. The mandate does contain an exception, and that's in quotes, for employers that require unvaccinated workers to undergo weekly COVID-19 testing and wear a face covering at work in lieu of vaccination. But employers are not required to offer this option. That's an important point. Employers are not required to offer this option. And the emergency regulation purports to preempt state laws to the contrary. Unvaccinated employees who do not comply with OSHA's rule must be removed from the workplace. So all of the people that were saying this is really a testing rule, a vax or test rule, that's not accurate because it doesn't say vax or test. It says vax, and maybe you can provide an exception for testing if you want, but otherwise it's mostly vax. And also maintain all the paperwork. And also maybe you might need to hire another person to maintain all this extra paperwork. Because we're talking about employers of over 100 employees. I mean, I wonder how many businesses, by the way, that were like, that had 100 or 101 employees during this whole time that were like waiting with bated breath on this opinion. We're like, are we going to have to fire a couple people just so that we don't have to go through this whole mess?
Oh my God.
Lay people off for some random reason that no one will ever know.
You gotta fire. Well, if you got 101 employees, you gotta fire 3, right? Because you gotta hire one back to take care of all the administrative stuff.
Yes. So. Yeah, exactly.
Sorry, I was gone there for a second.
Oh, that's all right. That's all right.
Things in the real world, you know how it goes.
Oh yeah, of course. Real things, real work, real, people.
I was listening though in my ear, and I heard Nate, ranting at the chat because he's like saying things, and they don't even want those things to be true because they're so mad at all the things. They don't want anything to be true, and it can be frustrating sometimes. I feel your pain.
Even when you're saying things that are factually correct, right? It's just like, because those facts don't agree with their
here's the posture, and here's how the Supreme Court considers things in this posture, and here's why they're doing certain things, and here's why they're saying these are factual claims because of the particular posture. It's like, no, that's not true. And I'm like, you're not paying attention to what we're saying.
You're wrong, Kurt. You're wrong.
Try listening to the words.
Like, what? You can just read it for yourself.
It's funny because for me, when I see comments like that just don't make sense to me, I don't think think about it because I'm like, well, that just doesn't make sense. So why would I pay any attention to it? You're a better
person than me for sure.
It's not about being a better person. It's just like my brain is not triggered to think like. No,
you're better than me on this point. I'll give you every credit in the world because the stupid doesn't even process in your brain. You have somehow developed a filter in your brain, or a bypass in your brain where the stupid just completely washes over you and you don't even realize it happened because it was so stupid your brain just refused to accept it on any level. You have a better brain immune system than me because it just filters over you, where me, it fests my mind.
I don't know, or it's some weird defect in my mind that I don't have certain crosshairs that should be going off. I don't know. But let me finish this paragraph and then we'll continue. So as it says, but employers are not required to offer this option, and the emergency regulation purports to preempt state laws to the contrary. Unvaccinated employees who do not comply with OSHA's rule must be removed from the workplace, and employers who commit violations face hefty fines, up to $13,653 for a standard violation and up to $136,532 for a willful one. I mean, and the question is, what's the difference between a willful and a standard violation? I mean, how do you prove that? How many people are like, I mean, well, I meant to get the vaccine, but I did. I mean, maybe the difference between a standard violation and a willful one is the standard violation is on the paperwork that somebody didn't maintain someone's paperwork.
I guess a standard yeah, exactly. It's kind of like a negligence versus intentional. I think it's the we failed it versus FU OSHA.
Yeah, versus no, I'm not getting the
also,
juice.
How did they come up with these numbers?
They're in the regulation, right?
Well, that doesn't really answer the question, though. It's like, why 13,653? It's suspiciously precise.
Yeah, you know what? Yeah, that's a good point. That's a very fair point. I wonder. I don't know. I have no idea.
They are in the regulation. Those fines are in the regulation, but I think you're right. But where'd they get the 100 people number at? Where'd they get the 100?
Oh no, that they pulled firmly out their ass. And what was really interesting is when you go read the original regulation, it's been a long time, but when you go read it, the reason they picked 100 was because of administrative burden. It wasn't because of a health reason, right? So it wasn't that they were saying that 100 is a number, and if you cross this number, it poses more of a health risk versus not. That wasn't their rationale. Their rationale was purely administrative. It's like we think that companies less than 100 won't necessarily have the administrative capacity to administer this, that they don't have the staff to do it, which is a very strange argument coming from a health regulation. Hey, we think that this thing poses an imminent health risk. We think workers are in danger. We think that this is posing an imminent threat. In fact, to use the exact language of the statute, a grave danger. That's the magic language. This is posing a grave danger. But hey, if you don't have the administrative capacity to deal with the paperwork, it's not that grave anymore. There's a logic problem there somewhere for sure.
Maybe. Let me get a couple super chats, and then we'll continue on. Reno says, don't know how relevant it was, but didn't Congress, postal workers, and several other government agencies get exceptions to the mandate for the most cataclysmically lethal disease in the history of mankind? That's bizarre. I don't know the answer to that question of whether or not they did get exceptions. I know they did, what those exceptions were.
I believe there was some. Again, I'm not sure. I hate talking out of ignorance, but I remember reading somewhere where there was some administrative issues with the vaccine mandate for the Postal Service or something, and they had given like a extension to introduce it, which is 100% not fair. But I'm thinking that's what the person's talking about. But again, I have to research that again to check it out.
Okay. Bipolar Punch says, unrelated legal question. If Hilaria were to divorce Alec Baldwin, would her share be protected from Alec's civil suits? That depends. Depends on whether or not they contemplated the potential lawsuits, whether any lawsuits were already filed against him. I can't remember if he's actually named as a defendant in any civil suits yet. I know he's not in the Armorers lawsuit that was just filed like yesterday, the day before. But I mean, that's a frustrating answer to get. I know, but it depends. So it's
always the safest answer.
I know. Well, of course.
It always depends on the law.
And the facts, actually, more precisely. Leaf Sandiger says, if you have a company of 100, Legal Mindset said to two different companies that have 50 employees each. Oh, so it's a Legal Mindset smart. Said you might split it into two different companies and have.
I don't know how that would work. It's a creative idea. I don't know if that would work or not. I don't know how the regulation was written. I'm not. Yeah, because there could be some language in the rule that says, if your company existed beginning this date through this date, then you might still be on the hook for it, or something along those lines. I don't know. There's always a way that the rules can still snag that company, even with that creative choice.
Well, just also with the last piece too, I want to make sure it's clear about the due process piece of this, right? Mm-hmm. The reason why you go through notice and comment, because that's what it really is. It's about due process, notice and opportunity to be heard, which is the lowest level of due process. So if they're fining people based on not following this emergency rule and kind of skirting the due process aspect of it, this is another reason why the court under these emergency rules is very, very careful to nitpick on the process, because just imagine the government saying it's an emergency, and if you don't do what we say, you're going to be fined $130,000. You haven't had notice, and you haven't had the opportunity to be heard. So that's the reason why, here, with the court, I think rightfully so, it's really, really skeptical about making people pay such horrible fines if they don't comply with such a mandate.
Yeah. One more super chat, and then we'll get back to the opinion. Salty says, being retired, the OSHA mandate didn't affect me, but anyone other than OSHA can require I get jabbed. Employers may still require vax or termination. I don't know that anyone can require you get jabbed, but there is still a possibility that employers could have their own policies outside of this. So this opinion does, and I mentioned this on my social media postings about this yesterday, that this opinion does not mean that no one can require employees to get the jab, outside of
But
healthcare.
in the absence of a mandate, it does pose potential liability for corporations who mandate it now.
Yes. Yeah.
So there
liability
is
if
a
there's
potential
adverse
ability
effects.
to sue the company because it's no longer they're doing it because of operation of the law,
Right.
which would protect them. Now they're doing
Right.
it because they wanna. And
Right.
so if someone gets sick or injured or otherwise from the thing, then there's a liability issue there. So that's a new issue for corporate counsel today. Fun times.
Yeah, I'm sure there are a lot of team meetings going on today about this. And then one more. Brick Cormier says, going back to your earlier live stream, have a company with 75 employees and 200 quote unquote independent contractors. If you're going to get creative, get creative.
That independent contractors exposes the employees to the contractors to additional regulatory things. It's not a freebie for the employee because they now have to do a whole bunch of things they wouldn't have to do otherwise. So it would help you as the company, but it screws over the employee a little bit.
You mean the independent
contractor, whatever we're calling them today? Yes,
the worker, we'll say.
The worker, yes, it screws over the worker a little bit.
Potentially. So Renal Ryan says, I work in retail in contact with dozens of customers every day that don't wear masks, but somehow my job is at risk because if I choose not to get vaxxed or mandatory testing. Yeah, that's
the OSHA rules full crap.
Yeah, I'm not sure what state you live in, but
yeah.
But the thing is, let's not forget too. I just want to make it very clear. A private employer can say, well, before you work here, we want you to be vaccinated. Right.
That's true too.
And there's really no issue unless you're in a state that's like Texas, where Texas has particularly banned that practice, or Florida, which has banned that practice. But there's some, for instance, drug test, right? You have to have the drug test, and some, so we're specifically talking about whether the government can mandate it, not individual employers.
Yeah. Agreed. A very important point. So part C here of the opinion says, OSHA published its vaccine mandate on November 5th, 2021. Scores of parties, including states, businesses, trade groups, and nonprofit organizations, filed petitions for review, with at least one petition arriving in each regional court of appeals. The cases were consolidated in the Sixth Circuit, which was selected at random pursuant to 28 U.S. Code Section 2112A. Prior to consolidation, however, the Fifth Circuit stayed OSHA's rule pending further judicial review. It held that the mandate likely exceeded OSHA's statutory authority, raised separation of powers concerns in the absence of a clear delegation from Congress, and was not properly tailored to the risks facing different types of workers and workplaces. That sounds like maybe what they're going to be saying.
But you know what the great part about this? For those same exact reasons why this went down, or for those same exact reasons, you could take that paragraph, and then that's the same exact reasons the next one, the Medicare one, survived.
Upheld.
Yeah, because it actually checked all those boxes that are saying unchecked here. Specific, not too large, the whole exact thing. And then have a separation of powers issue because the government is giving you money. If you take our money, we want you to do X. So this is, I think, the best paragraph in foreshadowing why Medicare is going to go down.
This one right here. Yep. So when the consolidated cases arrived at the Sixth Circuit, two things happened. First, many of the petitioners, nearly 60 in all, requested initial hearing en banc. Second, OSHA asked the Court of Appeals to vacate the Fifth Circuit's existing stay. The Sixth Circuit denied the request for initial hearing en banc by an evenly divided 8-8 vote. Chief Judge Sutton dissented, joined by 7 of his colleagues. He reasoned that the Secretary's broad assertions of administrative power demand unmistakable legislative support, which he found lacking. A 3-judge panel then dissolved the Fifth Circuit's stay, holding that OSHA's mandate was likely consistent with the agency's statutory and constitutional authority. Judge Larson dissented. Various parties then filed applications in this court requesting that we stay OSHA's emergency standard. We consolidated 2 of those applications, one from the National Federation of Independent Business and one from a coalition of states, and heard expedited arguments on January 7th, 2022. The Sixth Circuit concluded that a stay of the rule was not justified. We disagree.
Another Fifth Circuit was like, yay!
I'm going to bounce for a little bit. I might be back though.
Yeah,
Okay, sounds good.
I have to go in like 5 minutes. Too,
Okay,
so.
okay. And before we get into this, David Hamilton wanted to know what liability a company will have if they require it. So liability would be if an employee, if the only reason why an employee gets the vaccination is because their job is telling them to, if they have an adverse effect that has, some substantial damage to them, you could say,
Actually,
for what's that?
I don't think they would have any cause of that, because don't forget there's that fund. All right, so if your job says you have to get a vax shot before you can be employed here, and if that vaccine is approved, then there's a fund that if you get vaccinated and you have an adverse reaction, you then sue the fund. So Congress has there's like a law. There's already a workup where and it's weird because each pill, when it was pills, each pill, there's a tax on each pill, and that's like 7 cents goes into this fund. And if you have a negative reaction to an approved vaccine, you get money from that. You sue that fund and get the money from that fund. So it absolves companies, it absolves the government, it absolves everyone else. Even the drug companies are absolved from any liability based on this fund.
I forgot about that fund. I've actually I worked on a conservatorship case once that was the conservatee was I guess you could say a victim of one of those adverse reactions, and so the funds were coming in. The funds for the conservatorship estate were coming in from that fund. But that's
I think it's an average of $500,000 they pay out. I think they said average of $500,000. So it's crazy.
And she was very young when it happened too. So it's like she was getting quite a bit of money. I mean, it was her entire life. It was a very sad case, really sad case. But but yeah, so that's that's a fair point. They do have that. But so I wonder, I then what other ways could there be liability? I forgot about that fund.
That was the reason for the fund, because remember, first the approvers of the people who created the vaccine was saying, well, we won't want to create vaccines if someone has an adverse reaction, they can sue us for all our profits. So then it was kind of like, well, how can we do this in a way? Because then we have businesses like schools, local school districts who also, say, well, we want to, like for a hospital, we want to tell people they got to get vaccinated, but we don't want to get sued because, so we're not going to do it. So this was a way to kind of, make it so if people are hurt by this vaccine, they get money, but also the individual companies are not held liable.
So I wonder though, because the Pfizer vaccine has so far been approved by the FDA, right? But none of the other ones have been at this point, right?
There's like another little fund that they have for that one. Like there's two separate funds. There's one for like emergencies, and then there's one for like the vaccine. So like the Comirnaty, that's not in use yet. So so you can't get it, but there's still like another fund that gives you that.
Okay. So even for the other ones like Johnson & Johnson, Moderna, and all these, like there is a separate fund for them. That's just not the main vaccine fund.
Yeah. There's like some protection for, yes. So there's like a separate fund for just emergency use, but it's not. I don't think it's that big because there's not really many emergency use authorizations. But the one for the ones that are like if you have an adverse reaction to polio vaccine, you sue the big fund and you can definitely get some good money.
Right. Yeah. That's okay. So that's well, I stand corrected on that. Unless there's some other basis for liability, I don't know of it. But that's an interesting point. Suckett says, Nate, thoughts on Marilyn Mosby?
Who's Marilyn Mosby?
I don't know. I thought maybe you would know. So okay, well then, maybe they can explain at some point, but something tells me that might not be related to this conversation. So we'll get back to the opinion.
I gotta check it out.
Yeah. So turning back to the opinion, applicants are likely to succeed on the merits of their claim that the secretary lacked authority to impose a mandate.
Can I stop?
Yeah.
Marilyn Mosby is the DA. Law Self-Defense just did a video on it this morning. She was the Baltimore prosecutor. Was she Baltimore? She was in Maryland. But yeah, they believe she's under federal charges. You remember the Freddie Gray trial? Freddie Gray, the guy whose back was broken with the cops, And this was
was he the guy that he was like in a van with
them?
Okay.
Yeah. And she was just arrested and she's being prosecuted on some federal charges for like COVID-19 home loans and stuff like that. Yeah, she's going down hard. Very
that's
hard.
Interesting. That's interesting. That maybe that'll.
Some people are writing about it in the chat now too. Freddie Gray.
Okay.
Yeah, Freddie Gray, Baltimore prosecutor. Yeah.
Okay.
She doesn't look good for her. She's facing 30 years. It sucks to be a prosecutor facing 30 years. Like,
oh boy, I can't even imagine what that would look like. Woof. But that's interesting. All kinds of dramatic details in there. It sounds like. I'm gonna want to check that out later. So applicants are likely to succeed on the merits. Administrative agencies are creatures of statute. They accordingly possess only the authority that Congress has provided. And this is one of the big main points here. And the reason why, we were talking about Jacobson v. Massachusetts earlier, that really is not the reasoning from that opinion is really not relevant in this kind of a case, because we're talking about these are two different avenues of reasoning for whether or not this rule or this law can actually can properly be issued, because that's coming from a state. It's a different kind of authority. This is coming from a particular congressional statute that made this government agency. The secretary has ordered. Oh, sorry, did you want to say something?
Yeah, but I want to actually even go farther. The way Jacobson actually plays out, if your state was to do what OSHA just did and said every company, like if the state of New York put a rule in place to do this, they would actually be 100% allowed to do it. They would have no constitutional issue, right? Based on Jacobson and based on the police powers of the state. Mm-hmm. So we're talking, but the federal government is a government of limited jurisdiction. So that's the difference here. The state has general jurisdiction to do this. So if we were talking about a state making these type of rules, if the state took this same rule and made it in New York State, we're going to make this rule more than 100 employees, which they have done, which New York State has done. That's why it can't be challenged in federal court, because New York State has the power under the Constitution to implement such policy.
Yeah, that's a very, very interesting point, and it makes me wonder why different states haven't just decided to enact these kinds of rules, like California and New York, some of the more liberal ones that seem to be much more likely or much more likely to enact these kinds of rules. But I don't know. Interesting stuff. A couple super chats and then we'll get back to it. Renal Ryan says, wouldn't requiring a vaccine to get a job go against the Equal Opportunity Employment Act, though? Seems like discrimination at that point.
It all depends on what the job, because even when we read through not this opinion, but the second opinion, it clearly states there that some, and even here, it even states that some jobs and some employment, for instance, if you're working with COVID vaccine as a researcher, they can say as a part of your job description. Matter of fact, that's the thing that when you read this, when we go through it, they actually make that statement here, where if you're a vaccine researcher working with live virus,
yep,
they can say you need to get vaccinated. So that would not violate the Equal Opportunity Act. So so we'll get to it aside here, but that's a very good question.
Yeah.
But yes, certain jobs, and that's the problem with this one. They're saying this was too broad, but if you narrow it down, then you won't have a problem.
And to sort of highlight this kind of distinction, you're in different contexts, different cases. Let's say, take for example the rule that you're not supposed to discriminate in an employment context on the basis of sex, right? Like you can't just have a policy that says men get this job, women get this job. However, there are certain physical limitations to certain jobs that people will have to meet. For there have been cases, for example, on the airline industry. So to be a flight attendant, you have to be below a certain height actually in order to be a flight attendant, and you have to be able to, there are certain physical requirements, not just to be able to lift things and push things like an emergency door, but also like if you're too tall to stand properly in a plane, that's going to be a serious limitation on your ability to do your job. So there are ways that you actually can discriminate in ways that otherwise in other jobs would be unlawful but that in certain jobs, because of the specific requirements of that job, that they are not unlawful in that particular context. Hunter says, Nate, slightly off topic, but do you think it's possible to get out of the NYU booster mandate with a religious exemption?
Yes, I've helped someone get out. The NYC, I don't know if it wasn't a booster mandate, but they were mandated to get the shot, and the job said, the job was like, hey, you got to get the shot, or you I don't want to get too much into it, but you can't work here anymore. But there was a form that they had us file. And so we filed the form, and I filed it for them, and they got the religious exemption. But there were still other restrictions, like for instance, they had to make reasonable accommodation from the work from home. They couldn't. So there were other things that they had to do. But yeah, but you could get out of the requirement with the religious exemption. Just speak to an attorney, because I found whenever you have an attorney, it makes the process so much simpler, because they don't want to go through the BS. And
Hunter is he or she they just commented also that they mean NYU as a student.
All right. Well, no, NYU is a private institution, so you may have a little problem with that. You may have, but even them, they have to. I believe they still would have to have a religious exemption. But again, you got to speak to somebody, particularly if you have to go. What's their policy? What's going on, and get that, and then you have to apply that to theirs. So. If you email me, and I'll see what I can do for you. I've had a couple of cases against NYU, so I know a couple of other things. Yeah. NYU's they've been good to me.
Nice. Christian Rennie says, how can liability be proven in court for infection? Can't I just go out and be exposed to a person with COVID and blame company or the government for not adhering to mandates, etc.? I mean, I think, are you referring to if there was an allegation that you would get infected at work, or that you would be, for example, in the other case, a healthcare worker that's infecting other people? I'm not sure I understand the context of your question here. I don't know, Nate, do you have some thoughts on that?
I don't know. It's how can liability be proven in court for an infection? So I think that's the core point of this. I don't know if to be honest with you, I don't see it, because you can be affected unless you can directly, because usually you're talking about causation. That's what this question is really coming down to, right? It's a cause and effect analysis. Can you show that I got this here? With COVID, that's the reason why we have trials. So you'd have to.
And I would say that's a very difficult point. I mean, because right now people are getting sick left and right. So who knows? You can't, unless you were a total recluse and you only went and saw one person and then got got sick. You could reasonably say that person got you sick, but that's just not the reality for most people today. And by the way, Nate, so Hunter is asking what your email is or where they can get it. So
I don't know if you're on Twitter. You can just DM me on Twitter, or you can do my business email from my YouTube channel. So just go to YouTube and click email my channel. Just go click email and then just do it that way. Yeah.
There you go. Classy Mom says, thinking outside the box, how does this not violate informed consent when data testing and pre-testing results are sealed and even adverse effects are not disclosed at the time of the poke? So, I mean, that's a fair question, but so in order to get informed consent, you don't necessarily need to know everything that there is to know about a certain procedure or about a certain, medical treatment. So in order for informed consent to be properly given, the informed side of that is that a doctor has to tell you these are the risks. Let's say it's surgery. These are the potential benefits that you're going to get. These are the potential risks. There's this kind of a chance of this happening, this kind of a chance of this happening. You decide based on your comfort level. So, when data testing and pre-testing results are sealed and adverse effects are not disclosed at the time of the poke, I mean, to a certain extent, though, a lot of these adverse effects have been disclosed at the time at which that data has been available to these different agencies, right? I mean, that's at least my understanding. I'm sure we're going to get people in the chat that are going to be saying you're naive and you're too trusting. But I have seen, these studies that were done, that were put out by, by various testing groups. We're going to add this to the stream. about talking about how there's, risks of developing myocarditis and all of these other kinds of things. So I think that they're probably, from what I have seen, there is enough information out there, generally speaking, about these vaccines for people to properly give informed consent, for looking at this from a legal perspective.
And generally, informed consent is there's like there's a process. Like usually there's like a checklist that they go by to get informed consent. But I just want to, but just so everyone is so everybody's on the same page too. This, what you're looking at here, is the National Vaccine Compensation Program. So if you have any ill effects from the vaccine, you go here and you fill out a claim, and you can actually see countermeasures, injuries, for compensation programs. So there's one specially for COVID-19. So this is what stops drug companies and other companies from being liable for if you have ill effects with the vaccine. So there's an actual national fund, so you guys can see it. It's called the National Vaccine Injury Compensation Program.
And this is under the Health Resources and sorry, you closed out of it. Health Resources and Services Administration webpage. Correct. So for everyone listening on the podcast.
Hopefully, but listen, I gotta go. Hopefully that piece of information. So if you do know anybody who took the vaccine and may have some ill effects, you can send them there, because that'll be very helpful to them, and they can get paid. But listen, I will definitely see you later. Listen, chat. I know we fight all the time, and I know. But I still love you guys anyway. And hey,
of course,
and I think people in the chat should always understand, if you agree with everything I'm saying, then how do you know what I'm telling you if I'm not just telling you what you want to hear versus what I believe? So, but hopefully with that, love you guys in the chat. Alita, you are amazing, and thanks again for this opportunity. And I'll see everybody later. Of course,
thank you for joining me. This is always wonderful.
Thank you, guys.
All right, see you, Nate. Super Iron Bob says the standard for getting paid by that fund is unconscionably high. I haven't actually looked at the standards for getting paid out of there. So I don't have any data to agree or disagree with that statement. But I'm going to once again share the screen so we can talk about the opinion on the OSHA rule. So returning to it, we're in part 2, section A. It says applicants are likely to succeed on the merits. Oh, we talked about this, about how administrative agencies are creatures of statute. They accordingly possess only the authority that Congress has provided. The Secretary has ordered 84 million Americans to either obtain a COVID-19 vaccine or undergo weekly medical testing at their own expense. This is no everyday exercise of federal power. It is instead a significant encroachment into the lives and health of a vast number of employees. And then they cite to Alabama Association of Realtors versus Department of Health and Human Services, where the court had said, we expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. And that, by the way, that case that they just quoted was from their opinion on the what's it called, the rent moratorium. Where they were looking at basically this exact same analysis, right? We were talking, excuse me. I don't know what's going on with me. It's not COVID, guys. I already had it. But so in that case, remember, they were talking about whether or not the CDC had the power to issue a moratorium on people's rent and to justify it under notions of public health, right? That this is, to protect public health, that rent is a matter of public health. So, I mean, they made it really pretty clear that that Congress has to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. So, they go on here to say there can be little doubt that that OSHA's mandate qualifies as an exercise of such authority. The question then is whether the act plainly authorizes the Secretary's mandate. It does not. The act empowers the Secretary to set workplace safety standards, not broad public health measures. And no provision of the act addresses public health more generally, which falls outside of OSHA's sphere of expertise. So This is a very important point that they're saying that this has a vast potential economic and political significance, and OSHA is really only able to issue rules having to do with workplace safety standards. So we're already getting hints here from this opinion that this is probably OSHA overreaching outside of their outside of their bounds here, just like the CDC did with that eviction moratorium. The dissent protests that we are imposing a limit found no place in the governing statute. Not so. It is the text of the agency's Organic Act that repeatedly makes clear that OSHA is charged with regulating occupational hazards and the safety and health of employees. The Solicitor General does not dispute that OSHA is limited to regulating work-related dangers. She instead argues that the risk of contracting COVID-19 qualifies as such a danger. We cannot agree. Although COVID-19 is a risk that occurs in many workplaces, it is not an occupational hazard in most. COVID-19 can and does spread at home, in schools, during sporting events, and everywhere else that people gather. This kind of is like we were sort of talking about that with that super chat earlier, right? How well can one person prove that they got COVID from a particular source, right? Because people can get it from pretty much anywhere. That kind of universal, so going back to the opinion, that kind of universal risk is no different from the day-to-day dangers that all face from crime, air pollution, or any number of communicable diseases. Permitting OSHA to regulate the hazards of daily life simply because most Americans have jobs and face those same risks while on the clock would significantly expand OSHA's regulatory authority without clear congressional authorization. So this reasoning is almost exactly like the eviction moratorium. Going back to the opinion, the dissent contends that OSHA's mandate is comparable to a fire or sanitation regulation imposed by the agency, but a vaccine mandate is strikingly unlike the workplace regulations that OSHA has typically imposed. A vaccination, after all, cannot be undone at the end of the workday. This is a very important point here. Because, just like we were talking about earlier, OSHA has rules for washing your hands, wearing gloves, wearing protective, masks, wearing certain helmets, certain gear while you're on the job. All of those things can be taken off. All of those things are things that won't necessarily follow you when you go home, but you can't have that same sort of division between when you're on the clock and when you're going home when it comes to a vaccine. A vaccination, after all, cannot be undone at the end of the workday. Contrary to the dissent's contention, imposing a vaccine mandate on 84 million Americans in response to a worldwide pandemic is simply not part of what the agency was built for. That is not to say OSHA lacks authority to regulate occupation-specific risks related to COVID-19, where the virus poses a special danger because of the particular features of an employee's job or workplace. Targeted regulations are plainly permissible. And this is really what's going to be doing work in the other opinion as well. We do not doubt, for example, that OSHA could regulate researchers who work with the COVID-19 virus. So too could OSHA regulate risks associated with working in particularly crowded or cramped environments. But the danger present in such workplaces differs in both degree and kind from the everyday risk of contracting COVID-19 that all face. OSHA's indiscriminate approach fails to account for this crucial distinction between occupational risk and risk more generally, and accordingly, the mandate takes on the character of a general public health measure rather than an occupational safety or health standard. In looking for legislative support for the vaccine mandate, the dissent turns to American Rescue Plan Act of 2021. And then they basically, I can just kind of summarize this and basically say that they were like, there's really nothing in there that they can find for support. If anything, the Senate disapproving the regulation on December 8th, 2021 says, is maybe support for the contrary. Then they go on to say that equities do not justify withholding interim relief. We are told by the states and the employers that OSHA's mandate will force them to incur billions of dollars in unrecoverable compliance costs and will cause hundreds of thousands of employees to leave their jobs. For its part, the federal government says that the mandate will save over 6,500 lives and prevent hundreds of thousands of hospitalizations. It is not our role to weigh such trade-offs. In our system of government, that is the responsibility of those chosen by the people through democratic processes. Although Congress has indisputably given OSHA the power to regulate occupational dangers, it has not given that agency the power to regulate public health more broadly. Requiring the vaccination of 84 million Americans selected simply because they work for employers with more than 100 employees, because that number was pulled out of thin air, certainly falls into the latter category. So, and that's basically the majority opinion in this particular case. So, really, what this comes down to is like I said from the beginning, does OSHA have authority to make this kind of a rule? It's not about whether or not this rule is a good idea. It's not about whether or not this rule is something that can save lives, et cetera, et cetera. It is whether or not this type of rule is properly put forward by this particular authority, because rules have to come from the right place, right? This is why we have a complex system of laws, right? Because you can't just have the Supreme Court making up new laws. And of course, there are people that are going to be talking about how the Supreme Court legislates from the bench all the time, depending on the case that we're talking about and the fact pattern and whatnot. But the truth is that Congress makes certain laws. The judiciary interprets those laws. The executive enforces those laws. So, that's just one example. Laws have to properly come from the proper authority. And that is also true when it comes to laws that are coming from specific agencies. They have to come from the authority that is given to them by the act which created that agency in the first place. So that's the conclusion on the OSHA on the OSHA opinion. Now for the CMS opinion, a lot of this really goes to a lot of people are wondering how you can have the Supreme Court landing one way on the OSHA opinion and then another way on the CMS opinion. And this is really where this distinction comes in. It's like we were talking about before about the level of nuance that was given in the two respective rules, because even though they're both vax mandate rules, they both have some slight differences, right? Because you have the one that has a number of exceptions. You have another one that does not. You have one that is given for people that work in a very specific high risk environment. You have one that is much more generically given. So these are some distinctions between the two rules just before going into the CMS opinion itself. But there's going to be a lot of weight that those distinctions play in the turnout of the two different opinions. So looking at the CMS opinion, I'll jump right into it. The Secretary of Health and Human Services administers the Medicare and Medicaid programs, which provide health insurance for millions of elderly, disabled, and low-income Americans. In November 2021, the Secretary announced that in order to receive Medicare and Medicaid funding, participating facilities must ensure that their staff, unless exempt for medical or religious reasons, are vaccinated against COVID-19. 2 district courts enjoined enforcement of the rule, and the government now asks us to stay those injunctions. Agreeing that it is entitled to such relief, we grant the applications. So, moving on to the reasoning for it. The Medicare program provides health insurance to individuals 65 and older, as well as those with specified disabilities. The Medicaid program does the same for those with low incomes. Both Medicare and Medicaid are administered by the Secretary of Health and Human Services, who has general statutory authority to promulgate regulations as may be necessary to the efficient administration of the functions with which he is charged. One such function, so one function of the Secretary of Health and Human Services, perhaps the most basic given the department's core mission, according to the court, is to ensure that the healthcare providers who care for Medicare and Medicaid patients protect their patients' health and safety. So the fact that this is pretty explicitly stated in the statute that grants authority to the Secretary of Health and Human Services, this is something that is very important. It's pretty explicit here, right? That the Secretary is allowed to make certain rules that provide for the protection of patients' health and safety. Such providers include hospitals, nursing homes, ambulatory surgical centers, hospices, rehabilitation facilities, and more. To that end, Congress authorized the Secretary to promulgate, as a condition of a facility's participation in the programs, such requirements as he finds necessary in the interest of the health and safety of individuals who are furnished services in the institution. So this is also, they are allowed to, so the Department of Health and Human Services is also allowed to tie these types of restrictions, these core functions, right, to funds that are given to these different healthcare facilities. Relying on these authorities, the Secretary has established long lists of detailed conditions with which facilities must comply to be eligible to receive Medicare and Medicaid funds. So we're gonna take a look at these lists and determine, are these kind of similar to issuing a vaccine in this particular case, or mandating a vaccine, I should say, or are they somewhere within the realm of that? If there's nothing that they've ever done before that's anything close to mandating a vaccine, then this probably doesn't fit within the particular scope of authority. But if they've done stuff like this before, and it's kind of been par for the course at this point, then this is probably going to be the kind of situation that does allow for this kind of a mandate. So going back to the opinion, such conditions have long included a requirement that certain providers maintain and enforce an infection prevention and control program designed to help prevent the development and transmission of communicable diseases and infections. And then they're going to go into more detail about that later on. So, going to Section B, on November 5th, 2021, the Secretary issued an interim final rule amending the existing conditions of participation in Medicare and Medicaid to add a new requirement that facilities ensure that their covered staff are vaccinated against COVID-19. The rule requires providers to offer medical and religious exemptions and does not cover staff who telework full-time. So this is already a distinction point between this rule and the OSHA rule, right? The OSHA rule was much more generic, and it had technically some exemptions for people that work outside, but they talked about examples of plenty of people that were, I think it mentioned groundskeepers and like lifeguards that didn't fit under that particular exemption, even though their job was almost exclusively outdoors. So in this kind of a situation, not only do they offer medical and religious exemptions, they also have an exemption for people that are teleworking. A facility's failure to comply may lead to monetary penalties, denial of payment for new admissions, and ultimately termination of participation in the programs. The Secretary issued the rule after finding that vaccination of healthcare workers against COVID-19 was necessary for the health and safety of individuals to whom care and services are furnished. In many facilities, 35% or more of staff remain unvaccinated. And those staff, the Secretary explained, pose a serious threat to the health and safety of patients. Now, I know there's going to be dispute probably in the chat about whether or not the unvaccinated actually do pose a great threat to the health and safety of patients. But again, just like we talked about earlier, the court is going to take these facts as alleged as true. The court is not going to be spending time trying to figure out whether or not that factual allegation is correct. They're not that's not the purpose of this kind of an opinion. So they're going to assume that it's true for the purposes of this analysis and move on. That determination was based on data showing that the COVID-19 virus can spread rapidly among healthcare workers and from them to patients, and that such spread is more likely when healthcare workers are unvaccinated. So, whether or not, we talked also earlier about whether or not, people that are vaccinated have a reduced spread of the disease versus no spread of the disease doesn't matter, right? Because I think most people probably would agree that people that are vaccinated have a less likely, even if it's a very slightly less likelihood, or a smaller likelihood, I should say, of transmitting the disease to other people, there is a reduced risk according to the data that's out there. He also explained that because Medicare and Medicaid patients are often elderly, disabled, or otherwise in poor health, transmission of COVID-19 to such patients is particularly dangerous. We haven't talked about it, on this particular stream, but the CDC has come out recently and said that that the vast majority of COVID-19 deaths have had to do with people that had multiple comorbidities, right? So I think this particular point is probably something that most people are gonna agree upon, right? Is that the particular patients that are on Medicare or Medicaid, if they are in poor health, the transmission of COVID-19 to them is going to be particularly dangerous because of these other comorbidities, right? Rather than somebody who's otherwise healthy. In addition to the threat posed by in-facility transmission itself, the secretary also found that fear of exposure to the virus from unvaccinated healthcare staff can lead patients to themselves forego seeking medically necessary care, creating a further risk to patient health and safety. Whether or not there's a high likelihood or a low likelihood, the Supreme Court doesn't care for the purposes of this analysis. So, continuing on, he further noted that staffing shortages caused by COVID-19 related exposures or illness has disrupted patient care. The secretary issued the rule as an interim final rule rather than through the typical notice and comment procedures after finding good cause that it should be made effective immediately. That good cause was, in short, the secretary's belief that any further delay would endanger patient health and safety given the spread of the Delta variant and the upcoming winter season. Excuse me. So I wonder if this would be a slightly different analysis if the secretary had made that analysis based on the Omicron variant, because they said specifically here the Delta variant. I don't know. That would be interesting. But I mean, it's a hypothetical that we really don't need to get into because it's not going to be, it's not going to be material to this anyway, because this is what they did. This is actually what historically happened, was the Delta variant was going on. And I know that the Delta variant seemed to be much more risky and much more severe, I think, than previous variants, if I remember correctly. And certainly much more so than Omicron for sure. All right, so portion C here. Shortly after the interim rules announcement, two groups of states, one led by Louisiana and one led by Missouri, filed separate actions challenging the rule. So that's the procedural posture. I'm going to skip through that. Part 2, Section A. First, we agree with the government that the secretary's rule falls within the authorities that Congress has conferred upon him. So this is the answer to question number 1, right? Is this the kind of rule that this government agency can make? And here's where they're going to go into why they think that it is within the scope of their authority. Congress has authorized the secretary to impose conditions on the receipt of Medicaid and Medicare funds that the secretary finds necessary in the interest of the health and safety of individuals who are furnished services. COVID-19 is a highly contagious, dangerous, and, especially for Medicare and Medicaid patients, deadly disease. The Secretary of Health and Human Services determined that a COVID-19 vaccine mandate will substantially reduce the likelihood that healthcare workers will contract the virus and transmit it to their patients. So this is a determination made by the Secretary of Health and Human Services. Now, note that the court on these kinds of issues, I've said it several times, they're not going to make their own factual determination, but in this kind of a case, they most likely are going to defer to an agency like this that studies this specific issue, right? So, the fact that the Secretary of Health and Human Services determined that is fairly dispositive for this kind of a case. He accordingly concluded that a vaccine mandate is necessary to promote and protect patient health and safety in the face of the ongoing pandemic. The rule thus fits neatly The rule thus fits neatly within the language of the statute. After all, ensuring that providers take steps to avoid transmitting a dangerous virus to their patients is consistent with the fundamental principle of the medical profession. First, do no harm. It would be the very opposite of efficient and effective administration for a facility that is supposed to make people well to make them sick with COVID-19. The little bit of irony that comes to mind with that, of course, is what we were discussing earlier. I think Joe brought it up about how so many hospitals are so severely understaffed. They are actually calling in employees that are testing positive with COVID, but asymptomatic, and bringing them back into work. So, I mean, that's a little bit of irony considering that detail reading this bit right now. The opinion goes on. The state and Justice Thomas offer a narrower view of the various authorities at issue, contending that the seemingly broad language cited above authorizes the Secretary to impose no more than a list of bureaucratic rules regarding the technical administration of Medicare and Medicaid. But the longstanding practice of Health and Human Services in implementing the relevant statutory authorities tells a different story. As noted above, healthcare facilities that wish to participate in Medicare and Medicaid have always been obligated to satisfy a host of conditions that address the safe and effective provision of healthcare, not simply sound accounting. So these rules that can come out of CMS are not just bureaucratic in nature, is what they're saying. It's not just a matter of like you have to jump through certain hoops on a more administrative kind of level. This is like they're able to actually make rules that have to do with affecting the actual care that you give to certain to your patients. Such requirements govern in detail, for instance, the amount of time after admission or surgery within which a hospital patient must be examined, and by whom, the procurement, transportation, and transplantation of human kidneys, livers, hearts, lungs, and pancreases, the tasks that may be delegated by a physician to a physician assistant or nurse practitioner. These are very detailed ways in which they can regulate the things that are going on inside these healthcare facilities. And most pertinent here, the programs that hospitals must implement to govern the surveillance, prevention, and control of infectious diseases. Moreover, the Secretary routinely imposes conditions of participation that relate to the qualifications and duties of healthcare workers themselves. As these examples, the examples that they give include requiring training of hospital personnel and staff on infection prevention and control guidelines. Another example is qualified dietitians must have completed at least 900 hours of supervised practice. Another example, specifying personnel authorized to use radiologic equipment. And the Secretary has always justified these sorts of requirements by citing his authority to protect patient health and safety. As these examples illustrate, the Secretary's role in administering Medicare and Medicaid goes far beyond that of a mere bookkeeper. Indeed, respondents do not contest the validity of this long-standing litany of health-related participation conditions. When asked at oral argument whether the Secretary could, using the very same statutory authorities at issue here, require hospital employees to wear gloves, sterilize instruments, wash their hands in a certain way and at certain intervals, and the like, Missouri answered yes. The Secretary certainly has, and this is in quotes from the state of Missouri, the Secretary certainly has authority to implement all kinds of infection control measures at these facilities. The court goes on. Of course, the vaccine mandate goes further than what the Secretary has done in the past to implement infection control. And this is I think we're getting to an important point here. But he has never had to address. Not quite yet. But he has never had to address an infection problem of this scale and scope before. In any event, there can be no doubt that addressing infection problems in Medicare and Medicaid facilities is what he does. Now, this is a very important point here. And his response is not a surprising one. Vaccination requirements are a common feature in the provision of healthcare in America. Healthcare workers around the country are ordinarily required to be vaccinated for diseases such as hepatitis B, influenza, flu shot, guys, and measles, mumps, and rubella. As the secretary explained, these pre-existing state requirements are a major reason the agency has not previously adopted vaccine mandates as a condition of participation. So that's a very, very important part here. All this is perhaps why healthcare workers and public health organizations overwhelmingly support the secretary's rule. Indeed, their support suggests that a vaccination requirement under these circumstances is a straightforward and predictable example of the health and safety regulations that Congress has authorized the secretary to impose. We accordingly conclude that the secretary did not exceed his authority in requiring that in order to remain eligible for Medicare and Medicaid dollars, the facilities covered by the interim rule must ensure that their employees be vaccinated against COVID-19. We also disagree. So going on to part B, we also disagree with the respondents' remaining contentions in support of the injunctions entered below. First, the interim rule is not arbitrary and capricious. And then they go through the standards for it. Given the rulemaking record, it cannot be maintained that the secretary failed to examine the relevant data and articulate a satisfactory explanation for his decisions to 1, impose the vaccine mandate instead of a testing mandate, 2, require vaccination of employees with natural immunity from prior COVID-19 illness, and 3, depart from the agency's prior approach of merely encouraging vaccination. Nor is it the case that the secretary entirely failed to consider that the rule might cause staffing shortages, including in rural areas. As to the additional flaws the district courts found in the secretary's analysis, particularly concerning the nature of the data relied on, the role of courts in reviewing arbitrary and capricious challenges is to simply ensure that the agency has acted within a zone of reasonableness. So that is really all that is required in order to show that he, in coming to the conclusions for this rule, that he was acting properly, and not with arbitrariness and capriciousness. That he has to have acted within a zone of reasonableness. That's all that's required. Even though there are potentially adverse effects, even though there are maybe more than potentially are adverse effects, maybe absolutely adverse effects, such as staffing shortages from a vaccine mandate. That is still something that is not necessarily going to be enough for this decision to not be proper. Other statutory objections to the rule fare no better. First, Justice Alito takes issue with the secretary's finding of good cause to delay notice and comment, but the secretary's finding that accelerated promulgation of the rule in advance of the winter flu season would significantly reduce COVID-19 infections, hospitalizations, and deaths constitutes the something specific required to forego notice and comment. So this is talking about that second part here, right? Did they issue the rule with the proper process? Because the first part was asking whether or not this is the type of rule that can be made by this type of agency. The second question is whether or not the rule was made with the proper process. Normally, it requires a notice and comment period so that people can object to it. They can be heard for whatever objections that they have for this proposed new rule before it goes into effect. But the exception to that, or one exception to that notice and comment period, is the emergency exception, which was used here. And in this particular case, the court found that this was this reasoning by the secretary was justified, that accelerated promulgation of the rule in advance of the winter flu season would significantly reduce COVID-19 infections, hospitalizations, and deaths. So that was enough for them. And what we know now about Omicron is not what the secretary knew at the time of promulgating this rule, right? We didn't know about Omicron. I don't think Omicron was even on the radar at that point. What people were talking about was the Delta variant, which was much more severe than the Omicron variant. And I think that's an important point to keep in mind. And then just before I wrap this up, and we cannot say that in this instance, the 2 months the agency took to prepare a 73-page rule constitutes delay inconsistent with the secretary's finding that was a finding of good cause. Second, we agree with the Secretary that he was not required to consult with appropriate state agencies in advance of issuing the interim rule. Consistent with the existence of the good cause exception, which was properly invoked here, consultation during the deferred notice and comment period is permissible. So basically saying that you can have that that consultation later on by deferring the notice and comment period to a later time. So really what this is that a lot of weight here is being a lot of what's being what's carrying a lot of water here for both of these opinions is how specific these different rules were and what kind of context these rules are existing in. So you have the OSHA rule, which is a generic rule for any company, regardless of industry, regardless of rules, regardless of varying risk levels across these different companies, that everybody has the same rule. It's just a blanket rule. It's a backdoor so that the Biden administration can mandate vaccines for pretty much everyone across the country. It's another way to try to find a justification for that, regardless of what types of reasoning they may have for employment purposes, because this mandate would not just affect employment, it would affect somebody's entire life, right? You can't just turn off the vaccine juice when you go home from work. This is something that affects your body 24/7. So they determined that this was outside the scope because of that, and because of the fact that it was much more bluntly written. There were no real material exemptions for, nothing along religious lines, nothing along disability lines or medical reasons for an exemption to getting the vaccine. Nothing along the lines of, what particular kind of work do you even work around people? Do you telework 100% of the time? Those different exemptions were in the CMS rule, and those are some of the biggest reasons why the Supreme Court came down on differently on those two. And this is basically what the court is saying. The court is not saying that this is either an endorsement or an indictment on vaccine mandates generally. This is whether or not these particular agencies can come out with these particular rules. Do they have this kind of power to issue these kinds of rules for individuals in these contexts? And it was the same exact question for the eviction moratorium. And under the eviction moratorium, the court said, no, CDC does not have the ability to regulate contractual obligations between landlords and tenants. In this particular case, for the OSHA opinion, the court said, no, the Occupational Safety and Health Agency does not have the ability to require the populace, all employees at these big companies, to take on certain medical treatments or what have you. So this is outside the scope of what you are able to do as an employment agency. As far as CMS is concerned, CMS is concerned with the health and safety of the patients and maintaining. This is one of the core functions there, or one of the core concerns there with CMS, is maintaining the health and safety of the patients that are being seen at these facilities that are receiving the funding. And generally speaking, when it comes to congressional funding, the power of the purse is one of those things that it has throughout judicial history. That is one of the stronger ways that the federal government is able to give all kinds of strings to attach to people that otherwise Congress wouldn't be able to do. It's the power of the purse, right? So this is so the CMS rule was one of those cases where the court actually said, yes, this is actually a rule that is properly coming from this particular agency. And yes, this does fall within the emergency exception to the normal due process procedures for this kind of a rule. So anyhow, this has been a wonderful long live stream. thank you so much to everyone that has stuck through this. I want to thank also, I want to thank Nate the lawyer. I want to thank Uncivil Law. I want to thank Good Logic for coming on and chatting with us. Our discussion earlier on these two cases was awesome. And I really, really appreciate all of those guys coming on and having great, vigorous and passionate discussion and disagreement and you know, and just overall a great time. So, and thank you to everyone in the chat. Thank you to all of the mods. This has been really, really great. So with that, give us your thoughts in the comments below. If you haven't already, be sure to like the video, subscribe to the channel. If you are subscribed to this channel, make sure, double check that you are. Make sure that you're not getting unsubscribed, because I think I've gotten some notifications from some people that they went back and saw that they had been unsubscribed after particularly subscribing. So on that note, I will see you guys